We're live streaming the final round, just staying out of the room is hot, so let's move on.
Your motion, would you guys be fine with our Wilson's? I don't think this was an accident. No. No statements at all about how they perceived it.
To do that.
Yeah. Okay. You're an expert. You're an expert. Ask about it else, but I do. So all Dalbert challenges.
What is his expert classification? Like, what is he an expert for? Specifically? He's a statistician, right? So, yeah.
And he's a tennis analyst and statistician.
I don't think that.
It's exactly.
Thank you.
How did you get that? You say that's embarrassing. How did you get? Yeah.
If not, we hit all.
Check your email. See it, never. I know. What do we try to get on some sure?
Sure. Or projector.
Trying to figure it out. Hold on, let me get Judge Williams' phone. Hey, I'm sorry, excuse me, Judge. Before you- just have a second.
Okay, what's up?
We can't get into.
Hold on one second, what's up?
Yeah, we're trying to get this.
One second, we've got technical problems, Judge.
Good afternoon.
What are you looking to do?
You want it on there, and we'd like to have it on there, if you can.
Yeah, well, you gotta. Projector.
Probably open the window back then.
And because we're getting, look, it should now say all, it wasn't on all.
Okay, turn them on.
It should be, looks like it's probably on all right now, so. Yeah, it's on all right now, so, let's see, it's the witness box.
No, what, oh yeah, we're good.
Okay?
Yeah, the middle screen's on.
Great.
How are you?
I'm good, how are you doing today?
We're here as well. All right, the 295th is now in session, the Honorable Donna Ross presiding. And then y'all.
Don't you want to scoot down a few more? Okay, thank you.
All right, let's all go ahead and be seated, please. Okay, so we'll settle this, Mr. Chair.
What'd you say?
Final answer.
Final answer, you know how this chair looks up, because, there's a difference in my legs between.
Just a little bit.
Legs. You have to-
I'm gonna go the other way. I won't get yelled at. As long as I don't turn.
Just remember to lower it so she doesn't wave her finger at you.
Well, shall I have our legs?
And you want to sit them up.
Up?
Gotcha.
Thank you so much.
You're very welcome.
Thank
Good
you.
to see you.
All right, good afternoon, all. It's time to report is going to call, cause number U of H 281. The title of the case is Gardner versus De Silva. If I go ahead and get the appearances of the parties, let's begin with plaintiff's counsel, please.
Good afternoon, Your Honor. My name is Berkees Pierce. It's Brekeese. Last name Pierce, Pierce, alongside my co-counsel.
Hello, Your Honor. My name is Abigail Matthew, and we're here representing the plaintiff in this case.
All right, Ms. Matthew, if you will just spell your last name for me.
Yes, Mathew.
All right, thank you. And for the defendant?
Good afternoon, Your Honor. My name is Orly Golub. First name is Orly. Last name Golub, Golub as in boy. Along with my co-counsel.
Alexander Haney, last name spelled Haney.
Represent Nico De Silva in today's trial.
All right, is the plaintiff ready for trial?
Yes, Your Honor. But we do have a few housekeeping matters as well as the most in the one part.
Okay, great, thank you. Defendant ready for trial.
We also have a few housekeeping matters and a motion of the in three parts.
But are you ready for trial?
Yes, Your Honor.
Thank you. Let's move to the pre-trial matters. How can I help you, Mr. Pierce? If you are not arguing, you may be seated.
Yes, Your Honor. May we assume that all the witnesses have been pre-sworn,
Yes.
and may the jury charge be constructively read for the start of the closing arguments.
Yes.
And we would also like to invoke Rule 615, sequestration for the witnesses in this particular case.
Okay, are there any witnesses in the courtroom? Okay, you can stand up, please, and sworn. The rule has been invoked. It wasn't invoked constructively. You understand? Raise your right hand, all the witnesses. You solemnly swear or affirm that the testimony you will be giving in this case will be the truth, the whole truth, and nothing but the truth. Okay, the rule has been invoked, and at this time, all witnesses are hereby instructed that they are not to discuss this case with anyone else or among each other, and you must step out of the courtroom.
If I may, Your Honor, the defense does intend to call an expert today. As such, we believe that our witness should be exempt from Rule 615 as his testimony is essential to the defense's case today.
Okay, what does your expert witness intend to testify on?
Our expert witness is a tennis statistician and analyst. We anticipate that he will testify about the speed at which the ball that is the subject of today's trial was traveling when it left the racket of Nico Da Silva and unfortunately hit the plaintiff.
And what is it that the testimony you believe is imperative for him here in order to help with his opinion?
Our expert, Peyton Hewitt, should be able to hear the testimony of the plaintiff as to her perception of the speed of the ball, the angle at which it came. It's exactly what he will base his opinion in as the statistician in today's case.
Okay, request is denied. You must leave the room. You are also testifying. You must leave the room. It was not constructively invoked. Okay. Anything else?
That concludes our housekeeping. We just have motion in the meeting.
Okay, great. Thank you. And do you have any housekeeping matters, Ms. Katie?
Ms. Golub.
I'm sorry, I apologize.
No worries, Your Honor. We would like to ask the court's permission to move about the law freely during opens and closes.
That's fine.
And
Great.
we'd like to ask the court's permission on approaching the witness. Would you like us to ask permission every time or just the first time?
Every time.
I'd like to ask the court's preference on tendering experts. Does the court require a formal tender or is laying the foundation sufficient?
Laying the foundation is sufficient.
Lastly, Your Honor, we had a very productive meet and confer with Mr. Pierce and Ms. Matthew before trial, and we agreed to the pre-admission of 2 exhibits, and I'd like to give those to the court now if you're in.
Okay, what are those?
It'll be Exhibit 4 and Exhibit 6,
Are they plaintiff's exhibit or defendant's exhibit?
joint exhibits.
Okay. Mr. Pierce, is it the plaintiff's agreement to admit joint exhibit numbers 4 and 6?
Yes, Your Honor, that's good.
The joint exhibits of the parties 4 and 6 will now be admitted into evidence. Is there anything else?
Just motions, Your Honor.
Okay. Moving to motions and limiting, Mr. Pierce?
Yes, Your Honor. So this is a case about a person that was working within their field as a tennis worker, and they were unfortunately injured by the defendant in question. Your Honor, we anticipate that opposing counsel may try to have their defense witnesses elicit testimony as this being an accident, and we would object to this testimony as we believe it invades the privacy of the jury and it's purely speculative.
What would you decide that we should call
Just as pertains to the defense witnesses specifically, we do not want them to be able to say that this is an accident because that is.
it? And I'm asking, what should you refer to it as? Because this court handles motions in limiting mutually. What's good for one is good for the other. So tell me, what is it you want to call it?
An incident maybe, but not an accident because that hasn't been determined.
Okay, response?
Your Honor, part of the plaintiff's burden today is to prove intent. As a result, our witnesses need to be able to discuss their impressions of the incident as they observed it or as they studied it. First, we have our expert, Hewitt, and as I mentioned, he's a tennis statistician. He measured the frames and the speed at which the ball was going and compared that to the average speed of a serve. If allowed to testify, he will say that his opinion as to whether this was an accident or intentional is directly related to the average speed at which tennis balls are hit. And as an expert, he should be allowed to opine on the heart of this case. Additionally, we bring Devin Fuentes, who was there for the accident and viewed it. And so he has personal perception, personal knowledge to be able to tell the jury his impressions of the incident.
Okay, the motion and limiting will be overruled. Do you have anything else?
Nothing further, we're ready to proceed.
Okay, thank you. You may just take just Scotland, anything on limiting?
Yes, we have motion limiting in 3 parts. Your Honor, as you're aware, this proceeding is bifurcated per stipulation number 1. As a result, we'd like to exclude any mention of the plaintiff's pain and suffering, as we are only here to discuss liability, and any discussion of pain and suffering would be contradictory to the stipulation both parties have agreed to and inadmissible under 4.3.
Okay, response?
We don't plan to get too in depth within the pain and suffering, just that there was harm and that she was injured, Your Honor.
Subject to plaintiff stipulation that they do not intend to get into it, but just discuss harm. The motion will be granted, but you are allowed to talk about that they were harmed as a result of being hit with the ball. Anything else?
Just really quick, Your Honor, for clarification, does that also include the type of injury?
It
The
does
same,
not.
you know.
We'll talk about the type of injury that was sustained.
Okay.
Your Honor, we anticipate that Kelly Dunkirk, called by the plaintiff, will attempt to testify about a previous incident where Nico De Silva, who is alleged by the plaintiff to have hit their client with a tennis ball, that in the past he had a similar incident. You'll learn Ms. Dunkirk was not present for this incident. She doesn't know any details about it. And in addition, any testimony about previous incidents involving Mr. De Silva and other line judges that were hit by a ball will be improper character evidence under 404 used by the plaintiff to try and argue that because it may have happened that day, of course it happened today.
Okay, the charge that you've been given, is it a negligence charge or is it a premises charge?
Negligence, Your Honor.
So there's no premises charge as to being in knowledge of prior incidents.
That's correct.
Okay, response?
Yes, Your Honor, the significant part of this case has to do with recklessness, and we believe that goes directly to notice that the defendant was on, things of this nature happening, as well as a lack of accident. So we believe that it should definitely, be heard by the jury.
Let's see the charge. Thank you. Are there any instructions with the charge?
Yeah, the instructions are that section.
Yeah. Okay, that'll be overruled. Anything else?
That concludes our motions in limine, Your Honor.
All right, ready for opening statements.
Yes, Your Honor, we are.
Okay, you may proceed. Do you have a timer?
Our timers have been sequestered.
I guess that's now.
You have now both assumed new positions in the courtroom as two timers. Thank you so much. All right. You may proceed on oath.
Thank you, Your Honor.
Ms. Matthew.
Yes, thank you. May it please the court.
Of course, thank you.
Good afternoon, members of the jury. This case is about a professional tennis player who knew the rules, broke the rules, and injured Cam. My name is Abigail Matthew, and I'm here along with my co-counsel representing Cam Gardner in this case. I want to take you back to September 3rd of 2023. Cam is a volunteer judge or line ball crew member at professional tennis tournaments. So all that means, as you're going to learn throughout trial, is that he's standing on the edge of the court voluntarily to call whether a tennis ball in a tennis open competition is going to come, is in or out of bounds. Now, you'll learn that Cam has done this for many years. It's not new to him. And you'll learn that in all his years of being a volunteer line caller. He's never been hurt. And you'll learn how excited he was to volunteer for this specific championship game. Because his hero star player, Nico da Silva, was going to be playing. But you'll learn that his excitement quickly turned into injury. His excitement quickly turned into pain. On that day, September 3rd of 2023, Kim was standing on the edges of the court. He's watching the court just like always, alert, vigilant, because a ball could get thrown at any second. As he's standing there, in the 5 seconds, maybe even 2-second break after a call has been made, he gets hit in the throat by a ball that was intentionally or recklessly thrown in his direction. And you'll learn exactly why we know that that's true. Kim's going to get on the stand and he's going to tell you that he was watching the court. That's his job. That's why he's there. He doesn't take his eyes off the court. He's going to tell you that as he's watching the court, he notices the demeanor of Nico da Silva, his hero. He's noticing that Nico da Silva is missing shot after shot and the game is not going the way Nico wants it to. And you'll learn that as Nico gets a call on his ball as out of bounds, an unfavorable call, he acts out in anger. I'm sure we've seen it on TV before, of just hitting a ball at the side of the court out of frustration. But this time, there was injury. This time, Cam was hurt and in pain. You'll learn that he had to go to the emergency room and ultimately broke his larynx. That it took weeks to heal and months to get his voice back. And if it wasn't for the act of Nico da Silva hitting that ball recklessly in his direction, we wouldn't be here today. And I anticipate the defense is going to put on a couple of witnesses of their own. I anticipate that you're going to hear from Nico da Silva's partner, Devin Fuentes. And I anticipate that they're also going to call up Peyton Hewitt, an expert in tennis statistics. Now, I want you to pay close attention when Mr. Peyton Hewitt comes up to the stand. I want you to notice the intentions and motives behind what he has to say. Because you're going to learn that this is not just like any other expert in a trial. This is not someone who was subpoenaed or required to testify in this case. This is someone who was hired by the defense at $15,000 for a testimony. And I want you to pay attention to Mr. Hewitt, because you're also going to learn that if the defense wins this case, he gets an added bonus.
I'm sorry, you get to,
Added bonus.
thank
Finally, Mr. Hewitt's going to probably come up here and tell you that this could have been, or this couldn't have been avoided. This is unavoidable. But ladies and gentlemen of the jury, you'll find by the end of trial that this was avoidable. We wouldn't be here if Nico da Silva hadn't hit the ball directly at Cam's throat. Finally, ladies and gentlemen, I want you to notice you're not going to see Nico da Silva here today. He's not going to come up on that stand. He's not going to testify. He's not gonna even be in the room watching. And I want you to think to yourself why that might be. Because you'll learn that he's at another tennis game right now. All that being said, at the end of trial, you're gonna receive a jury charge. And you're gonna be asked by my co-counsel, Mr. Baptiste Pierce, whether the actions of Nico da Silva were so reckless that they caused the injury to Cam. And you're also gonna be asked whether Nico da Silva's conduct was a substantial factor in causing that injury. And we believe that at the end of the trial, you'll find that yes, his actions were so reckless and were a substantial factor in causing the injury to Cam. That's why we ask that you find the defendant liable. Thank you.
Thank you very much, Ms. Pierce. You will be doing opening.
I will judge. Alex.
Mr. Hanley, if you would like to proceed.
Your Honor, just to clarify, I'm Miss Matthew.
I'm sorry, I'm probably gonna get you off.
That's okay. I just wanted to make sure you knew.
May I proceed, Judge?
Yes, please.
Not every story has a villain. Ladies and gentlemen of the jury, my name is Alex Haney. And alongside my co-counsel, Ms. Orly Golub, today we have the pleasure of representing Mr. Nico da Silva. Now, I want to make it clear. See, we sympathize with the plaintiff's injury. We understand. But you'll learn from today's trial that we understand and don't dispute that plaintiff was injured. You'll learn today that Mr. da Silva is not the villain. Now, ladies and gentlemen, the day in question, September 3rd, 2023. If you were in the stands at the Eureka Open on that day, you would see a professional tennis match, the highest caliber. Balls flying at over 150 miles an hour, the best athletes in the world. And one of those athletes is Nico da Silva. Now picture this. It's the fourth round match. He's locked into his game, neck and neck. But it's unusual. He's not playing as well as he should be. He's having a bit of an off game. It's the first set, and he gets a tough call. Tough call, whether a ball was in, whether a ball was out. The call goes against him. That cost him set one. And that call was made by the plaintiff, Mr. Cam Gardner. And it's at that point that while he's locked into the zone, while he's focused on this important tournament for his career, match 4, that he turns around and underhands the ball towards the back wall. And unfortunately, that ball doesn't collide with the back wall. Instead, collided with Cam Gardner. And yes, it's true, he was locked in. He wanted to win. That was the priority, as any professional athlete would. But what you'll see today, ladies and gentlemen, is after Cam Gardner got hit, you'll learn Mr. da Silva immediately rushed towards her side. He goes out of his way to check if she's okay. Immediately. Winning's not on his mind anymore. What's important, you'll learn, is the well-being of this person. Now, you'll hear from 2 of our witnesses today. You'll hear from Peyton Hewitt, you'll hear from Devin Fuentes. And what you'll learn is that tennis matches, especially tournaments like this, you'll learn have various levels of employees. Naturally, you'll learn that they have tournament directors, as well as various other employees in order to handle the logistical side of things. That includes line judges, it includes ball boys, medical staff. You should also learn that it includes a head umpire. Ladies and gentlemen, go hear from one of those head umpires today. You will hear from Kelly Dunkirk. Kelly Dunkirk, who tried to purport Mr. Fuentes as the villain. What you'll also learn is that when Mr. Gardner got hit, you'll learn that he wasn't paying attention. He wasn't aware of what was going on. And now that I mentioned that point, you'll also hear from Mr. Gardner himself. And he'll tell you that he loves Nico. He loves Nico da Silva. Nico da Silva is his favorite player. He loves the game of tennis. He's been line judging for years. But what you'll also learn is that he's aware of the things that happen at tennis matches. He's aware of the possibility that anybody could get hit. And you'll also learn that right before Cam Gardner got hit, just like Kelly Dunkirk, he wasn't paying attention. Now today, ladies and gentlemen, the plaintiff bears the burden of proof in this case. And while it was already touched on during the plaintiff's opening, I wanted to add on to the actuality of the burden of proof. It was mentioned that one of those is recklessness. In reality, what Ms. Matthews failed to tell you is that it is intentionally or recklessly. They have to prove by a preponderance of the evidence that Mr. da Silva intentionally, purposefully went out of his way to hit Mr. Gardner or recklessly did so. Preponderance of the evidence, for those of you who don't know, is more likely than not. They have to prove to you that it's more likely than not that this athlete went out of his way to hurt somebody or did so recklessly. And even though the plaintiff's counsel will try to tell you that Mr. da Silva is the villain of the story, as you'll learn, an athlete who rushes to someone's side, ask yourselves this question throughout trial. Is somebody who rushes to someone's side immediately to check if they're okay a villain? Ask yourselves, is that somebody who would go out of their way to hurt somebody? And you'll learn today, throughout all of the testimony that you hear and all of the evidence that you see, that Mr. da Silva is not the villain of this story and is not liable. Thank you.
Anything call it first witness?
Thank you, Your Honor. Plaintiff calls Cam Gardner to the stand.
All right, thank you. Berger?
Yes, Your Honor.
All right, you may proceed.
Before we begin, Your Honor, did you have a preference on if we wanted this question for the seated position or not?
No, I don't have a preference. If you'll raise your hand. You promised in this University of Houston mock trial that you were gonna do the very best that you can for your team.
Absolutely.
Hello, Mr. Thank you, Your Honor. Hello, Mr. Gardner. How are you?
I'm good. How are you?
Good, thank you. Can you please introduce yourself to the jury?
Yes, my name is Cam Gardner.
All right, Mr. Gardner, just tell us a little bit about yourself.
I'm a tennis nut. I used to be a line judge, and I did that for about 7 years.
Okay, so let's talk a little bit about your experience as a line judge for the past 7 years. What exactly is a line judge?
So there are multiple judges on a tennis court. As a line judge, my real job is to watch where the ball falls. And so I'm looking to see if it's on one side of the line or the other, whether it's inbounds or whether it's out of bounds. I would make that call to the chair judge and they would make a decision about how to assign a point.
Okay. And what does being a line judge, what type of skills are required for being a line judge?
Like, you have to be really alert. You have to pay attention. You have to watch the players and you have to watch the ball. You have to be very careful. Because not only do you need to notice everything that goes on, but it can be dangerous sometimes.
And in your experience as a line judge, have you ever had anything negative or, anything like that happen to you?
I did in 2023. I was injured when I was hit in the throat by a tennis ball.
All right, let's talk about that 2023 incident when you were hit in the throat. What exactly happened?
So I was line judging at the Eureka Open Tennis Championship. And it was around with Mr. Nico De Silva. He's actually like a hero of mine. I really respected him a lot as a player. And I was a line judge for that round.
Now, talk me through that round from the beginning. What occurred first when you were being a judge being a line judge?
Well, Mr. De Silva was a heavy favorite to win. He's an amazing tennis player. But he seemed off that day. He was very slow in his movement. And so the favorite was falling behind. This became really apparent when he missed a pretty easy volley and grew real frustrated by it.
And you said he grew real frustrated. What did you see that indicated that frustration to you?
Mr. De Silva hit a ball really hard at the side of the court.
Now, let's talk about Mr. Silva hitting that ball to the side of the court. Was that the first time that you'd seen something like that from Mr. De Silva?
No, that round it was, but he was known for getting angry.
Objection, lack of foundation.
Okay, lay your predicate.
Yes, Your Honor, I can.
Lay your predicate.
Yes.
Judge, may I have the ruling on that objection?
I'm giving her a chance to lay her predicate first.
Okay, let's backtrack a little bit, Mr. Cam. How many times have you seen,
This is Bishop Gardner, right?
yes, Cam Gardner. How many times have you seen Mr. De Silva play a match, tennis match?
So this was the first match that I was a judge of. He was one of my favorite players. I've seen him play tennis before, but this is the first time I was on the court.
Okay, so I want to go back to talking about when he hit the ball to the side of the court. At what point did he hit the ball to the side of the court?
So this was when he missed a shot. It was a relatively easy ball. He missed it, and so he hit the ball toward the side of the court.
Okay, and then what happened?
Well, the round didn't get any better. So the score at this time was 5-6. So if he were to lose or miss one more ball, if he were to lose one more point, he would lose that round.
Okay, and so knowing that if he were to, miss that point, he was going to lose a round. What occurred next?
So Mr. De Silva was rushing the net to get close to the net, and the ball went by him. And it came toward me, and so I had to make a call when the ball landed.
Okay, thank you, Cam. And what was your call that you made?
So I called the ball in. I signed to the seat judge that it was inbounds. And so Mr. De Silva lost.
After you made that call, what did you notice?
So Mr. De Silva glared at me immediately. And it was unsettling. I was really nervous in that moment. But he was just staring right at me.
After that stare, what happened?
So he stopped glaring at me. He turned away briefly. So I started to relax. And then the next thing I know, I watch him hit a ball off of his racket, and it hits me right in the throat. And I fell to the ground. I couldn't breathe.
Now, if I were to show you a picture taken from that day of you falling to the ground, do you think you'd recognize it?
Yes, ma'am, I think I would.
Your Honor, permission to approach a witness with what's been pre-admitted as Exhibit 4 and also what's been pre-marked as Exhibit 5. Mr. Gardner, I'm handing you Exhibits 4 and 5. Now, without going into into the contents of that exhibit, do you recognize that exhibit, those exhibits?
Yes, I do.
Now, what is Exhibit 4 and what is Exhibit 5?
These are both photographs after I was struck by the ball.
Now, are these photographs a fair and accurate depiction of what you looked like after you were hit by the ball?
Yes.
At this time, Your Honor, I'd like to offer Exhibit 5 into evidence and publish the jury.
Okay, may I see the exhibit, please? Thank you. All right, are there any objections to exhibit number 5?
No objections, Judge.
Okay, exhibit number 5 will be admitted into evidence. You are, Mr. Gardner?
And permission to publish?
That's fine.
Now, what are we looking at here, Mr. Gardner?
So that was soon, I was wearing a mask at the time. That was after, I don't recall exactly how the mask got off, but we ripped the mask off because I was struggling to breathe so much.
And what about Exhibit 5? Or sorry, Exhibit 4?
Exhibit 4 is before the mask came off. That's me grabbing my throat.
Now, Mr. Gardner, I want to talk a little bit about what the order of what happened with the video. If I were to show you a video of the tournament from that day, would you be able to recognize it?
Yes, I would.
Your Honor, permission to approach the witness, what's been pre-marked as Exhibit 3.
Okay.
Actually, Your Honor, I'm actually gonna ask to approach with Exhibit 2 at this time.
All right, thank you.
Now, Mr. Gardner, in handing you what's been pre-marked as Exhibit 2, without going into its contents, do you recognize this exhibit?
Yes, ma'am, I do.
Okay. And what is this exhibit?
It is a transcript from the interview after the match.
And is this a true and correct copy of that transcript of the interview?
Yes, ma'am.
And is this an interview that you yourself have watched
Yes, I have seen it.
and you're familiar with this exhibit?
I am familiar with the interview.
Okay. This time, Your Honor, I'd like to offer Exhibit 2 into evidence and publish to the jury.
Is there an objection to exhibit 2?
Yes, Judge, objection to hearsay.
Can I see it, please?
Yes, Your Honor.
Your Honor, if I may respond to the objection?
As soon as I finish reading this.
Yes, sir.
Response?
Your Honor, this is not hearsay because we're actually using this as an effect on the listener to show how De Silva responded to the comments, and it also contextualizes the interview for the jury In addition, the statements inside made by De Silva are statements by a party opponent.
Response?
Yes, Judge, response to effect on the listener, I don't think foundation can weigh on who the listener is. This is being admitted through this witness who wasn't present for this interview, and as the foundation hasn't been laid that this individual is familiar with that. Additionally, we do concede that the statements made by Mr. De Silva are admission by a party opponent. However, the questions in the interview, as well as statements made by the moderator, are hearsay in which no exception applies.
Okay, the court is going to grant the hearsay exception, the hearsay objection as to the moderator comments. The comments by Mr. De Silva are admissions of a party opponent.
Understood.
Document will be redacted to take out the moderator comments, and exhibit number 2 will be.
Now, Mr. Gardner, I want to ask you some questions about this interview that occurred that you're familiar with. Do you remember watching this interview?
Yes, ma'am, I do.
And do you remember, Nico De Silva saying there's always a chance that you can hurt somebody on this court?
Yes, I do.
Do you remember Nico De Silva saying that his emotions sometimes play a part in this?
Yes, ma'am, I did hear him say that.
Do you remember him saying it's possible that his emotions played some part in this?
He did say that, yes, ma'am.
And do you remember Nico De Silva saying he has to work hard to control his emotions?
Yes, he said that too.
Do you remember Nico De Silva saying there was no need for me to hit the ball that hard, especially without looking where it was going?
Yes, ma'am, he said that.
Pass the witness, Your Honor.
Examination.
You may proceed, Your Honor.
Yes.
Good afternoon, Mr. Gardner. I just have a few questions for you. Now, as you testified earlier on, Direct, you're a volunteer line judge.
That's right.
You've been doing this for 7 years.
Yes, sir.
You love being part of this intersection,
I do.
and you are a big fan of Mr. De Silva, correct?
I was.
At the time of the incident, you were a big fan.
Yes, sir, I sure was.
So as an experienced line judge like yourself, you understand that there are risks associated with that position.
I do.
The risks associated with being at a tennis match,
That's right.
as well as being physically present on tennis court.
That's right.
So you'd agree that as a line judge, safety is an important factor,
Yes, sir, that's correct.
because according to your testimony, balls can be hit up to 150 miles an hour.
Yes, during the match, that's right.
Right. Line judges like yourself have to be alert at all times, correct?
That's right.
And you would agree with me that if you blink at the wrong time, you could get hurt.
I don't know if I would agree with that assessment by just thinking.
So would you agree with me that you testified that you said if you blink at a wrong time, you get hurt?
You can certainly get hurt in an instant, yeah.
I'll clarify for you. You've had previous testimony as to that exact phrase.
I think so, yes, sir.
So you also know plenty of line judges in your 7 years as a line judge. You know plenty of line judges who have been injured
That's right.
in the course of a match.
Yes, sir.
So why don't we go ahead and get into September 3rd, 2023. You were line judging that match, correct?
Yes, I was.
And this included the 4th match where Mr. De Silva was playing.
That's right. It was the 4th match.
And help me understand, you made an in call, that was a close call at the end of that match? Or excuse me, at the end of the first set?
Yeah, so during the service round, I called a point in that was against Mr. De Silva, and so he lost that round. Yes, sir.
And then after that, you mentioned that you had gone to the back wall, correct?
Yes, I believe I was at the back.
While Mr. De Silva was walking back towards the service line.
That's right.
And you also testified that you weren't really paying attention.
No, sir, I did not.
Well, you testified that you saw him hit the ball at you, or indirect.
I did.
But in fact, you actually didn't see him hit the ball at you.
I saw the ball hit off his racket. Yes,
So
sir.
did you see, I'll clarify, did you see him hit the ball at you directly?
I saw him hit the ball off his racket.
So
Yes, sir.
to clarify for the jury, what you saw was the ball coming off his racket. That was the portion that you saw.
No, I mean, I had a field of view. I could see him with the racket and I saw the ball hit off his racket. I didn't mean, he didn't suddenly disappear. He was
I can give you an example, sir. So if I were hitting a ball at you, or a ball at that wall, the portion that you saw would have been the ball leaving the racket.
I don't think that's correct. He was 40 feet away from me. I could see him and I saw him hit the ball off his racket.
Mr. Garner, has that always been your testimony?
That I saw him hit the ball off his racket.
That you saw him hit the ball at you, yes.
I testified that I saw him hit, like, I saw the ball. Forgive me, I'm getting confused now. I saw him hit the ball off his racket, yes.
Do you recall giving a deposition, sir?
I didn't give a deposition, but I did write it out.
An affidavit in preparation for this trial?
Yes,
Were you under oath when you made that affidavit?
I was.
That affidavit, that oath was to tell the truth,
Yes,
the whole truth,
yes,
nothing but the truth.
that's right.
And you're under that oath right now, correct?
Yes, I am.
Judge, may I approach the witness of your affidavit?
Your Honor, I'm gonna object to improper impeachment here. May we assume we're outside the presence of the jury?
Yes.
I believe what opposing counsel is about to get into is a statement in the witness's affidavit that the witness has not actually denied or has not actually contradicted. The witness has maintained his position that he saw a ball fly from his racket, and that is what the witness is testifying to.
Okay, well, let's go ahead and wait until he actually gets into it before we make an objection.
Understood.
May I approach it?
Yes.
And now, Mr. Gardner, I'm handing you a copy of your sworn affidavit. What I'd like you to do is,
Do you have a copy for the court?
I can get that, yes, Judge. At this point, I would like to direct the court's attentions to line 14 through 15. Starting, excuse me. Now, what I'll do, Mr. Gardner, is I'll point to line 14 through 15. What I'd like you to do is read that silently in your head as I read it out loud for the jury.
But that's not the way it works. You need to read it to yourself.
Would you mind reading this silently to yourself?
Okay.
And what is the question?
Can I read this out loud to the jury?
No. What is your question for the witness?
Did I read that correctly, sir?
I don't know if you read it correctly, sir. I just read it. to myself.
Is your memory refreshed?
Okay, first of all, get off the witness
Yes.
stand. Okay. What is the question you think you're impeaching him on?
I asked, Judge, so for clarification, I asked this witness whether or not he saw the Mr. De Silva hit the ball at him, or whether he saw the ball leave his racket. Those are the facts and differentiations.
Okay, now you have refreshed his memory, you've re-asked the question, you give him a chance to answer, and then you can read the statement in head.
Yes, Judge.
Okay?
Would you mind reading this silently to yourself as I read this out loud to the jury? But then out of nowhere, I saw a ball fly
Your
from
Honor,
his
I'm gonna object again.
It's sustained.
I'll move on, Mr. Gardner. At that point, after the ball left his racket, that's when it hit you.
Yes, sir. It struck me in the throat.
You also are aware that he rushed to your side,
He did rush over after hitting us.
and that was to check if you were okay.
Yes.
Judge, at this point, may I publish exhibits 4 and 5 to the jury? I believe they're already admitted as evidence.
Yes.
This is all I can do. Mr. Gardner, I would like to direct your attentions first to Exhibit 4. That's you in that photograph, correct?
Yes,
That is Mr. De Silva in that photograph as well.
I believe it is. Yes, sir.
Mr. Oliver, you put your slide on the slide, please. Now, Mr. Gardner, I'll ask the same question. That right there on the ground, that's you, correct?
Yes, it is.
And that person right there to your right, that is Mr. De Silva, correct?
Yes, it is.
No further questions, Judge.
Great, thank you. Is there anything I'll redirect?
Just briefly, Donna.
Very.
Yes. Mr. Gardner, does the fact that Nico De Silva came up to you after you were injured change the fact that he hit the ball at your neck?
No, it didn't change my crushed larynx either.
Does the fact that he came up to you change the fact that your larynx was broken?
Objection, Judge. I'd like to reintroduce and make a oral objection that first stipulated parties are not allowed to get into the actual details of the injuries. I believe that's been established already.
Okay, so, it's sustained. Move on.
And Judge, may I strike everything from the record after this? Yes.
Mr. Gardner? You did hear Nico De Silva say there was no need for him to hit the ball that hard, especially without looking where it was going.
Objection, asked and answered, and leading.
Sustained.
Nothing further at this time, Your Honor.
Okay, thank you. Mr. Gardner, you may step down.
Thank you, Your Honor.
And Mr. Gardner, be excused from the roll.
Yes, Your Honor.
Yes. You may have a seat in the courtroom, sir. You may call your next witness.
Yes, Your Honor, at this time, the plan calls Kelly Dunkirk to the stand.
Thank you. Mr. Clerk, if you would just write into my right, please. Coming up. I need you to raise your hand. You solemnly swear that in this U of H tournament that you will possibly do the very best you can for your team.
Thank you.
Okay, have a seat.
Good afternoon. Can you introduce yourself to the jury, please?
Yeah, hi, my name is Kelly Dunkirk.
Mr. Dunkirk, what do you do for a living?
So I'm actually an umpire for professional tennis. Essentially, I sit up in the big stand on the side and I rule things going on in the game.
Now, is this a new role for you or have you been in this role for quite some time?
No, I mean, I've been doing this for years.
Thank you. Mr. Dunkirk, do you recall the date of September 3rd of 2023?
Yes, I was, overseeing a tournament at that time.
Okay, and can you explain to the jury what happened on that particular day?
Yeah, so that was a tournament with, one of really the best tennis players. And there was an incident where, he hit a tennis ball behind him and hit someone right in the throat and got pretty injured.
Okay. Sir, can you give some type of context to the jury of how this incident, as you say, occurred?
Yeah, so, game wasn't going very well. It was still in the first set, but, about halfway through that set, Nico actually got upset and, hit the ball really hard against the wall when he lost a point, and essentially things started to build up and he was getting more and more upset about his performance.
Okay. You mentioned that he was getting upset and he hit a ball. Has anything like that ever occurred before?
Yeah, so I have a bit of history, as an umpire, there's not that many of us, so we'll preside over, maybe not preside, not a judge or anything, but we oversee these games and we'll see the same players multiple times. So if there have been similar incidents with Nico.
What in particular was there a time where his anger specifically caused an incident?
Objection, Your Honor, may we be heard outside the presence of the jury?
Yes.
Like to re-raise an issue we discussed motions in limine. I anticipate that the testimony Mr. Pierce is attempting to elicit from Mr. Dunkirk is improper character evidence under 404, trying to establish that because Mr. De Silva has been angry at matches in the past, he was obviously angry and reckless on this day. It's improper character evidence under 404.
Response?
Yes, Your Honor. Well, it goes directly to notice and it also goes to lack of accident in this case, which are both exceptions to Rule 404. I mean, that's exactly what I plan to get into with this witness as he saw this all take place.
Based upon the charge of intentional and reckless, the court finds the evidence pertinent and admissible. Your objection is overruled.
Yes, Your Honor. May we have a running objection to all testimony regarding character traits of Mr. De Silva?
No.
Mr. Dunkirk, was there ever a time where the defendant's anger specifically caused the incident as such?
I'm sorry, can you repeat your question? Was there ever a time?
Was there ever a time where the defendant's anger caused an incident as would occur with this plaintiff?
Objection, speculation.
Sustained.
What other incidents are you aware of, Mr. Dunkirk?
So, in previous games, Nico had basically similar issues with hitting the ball, getting upset at rulings. And so it really wasn't the first time that this had happened. It was a repeat thing of having disagreements with the umpire.
Okay, no further questions at this time.
Examination, please. If there's a standard, if you want to use it, would that be helpful?
I think I'm good. Thank you, Your Honor. May I proceed? Mr. Dunkirk, you don't really like my client, right?
That's fair to say. I think he's had a bit of an ego in the sport and it's rubbed me the wrong way a little bit.
Right. He's now one of your favorite tennis players,
Yeah, I wouldn't say my favorite.
and certainly not one of your favorites to umpire for, correct?
No, it can cause some issues umpiring.
Now, on September 3rd, you were there, right?
Yes, I was the umpire of the game.
You're sitting in a chair.
That's right.
And at the moment that the ball left Mr. De Silva's racket, you weren't looking, correct?
Yeah, I didn't see the impact initially, no.
You didn't see any of it, to be fair, right?
I've seen the video since then, but on the day, no, I didn't see it happen.
So on September 3rd, when Mr. De Silva hit the ball off his racket, you did not see it.
No, I heard it and I saw the aftermath of what happened.
You also didn't see the ball hitting Mr. Gardner, correct?
No, I saw the aftermath.
But despite not seeing the incident, it was your job to decide if you were going to issue a citation to Mr. De Silva. Is that correct?
That's correct.
And in order to issue a citation, you had to make a decision, right?
Of course, yeah.
You had to decide if Mr. De Silva had hit the ball with intent.
I didn't have to decide solely on intent.
Right, could have been recklessness as well, right?
Yes, that's right.
So you and your co-umpire had to make a decision about whether Mr. De Silva intended to or recklessly hit a ball that hit Mr. Gardner, right?
That's right.
And on September 3rd, when you were making that decision, you never saw the video.
No, I didn't need to.
You hadn't seen the incident happen.
I mean, I know that we were between rounds and he hit the ball behind him into a line judge.
I appreciate why you want to say that. My question was a little bit different. You didn't see the incident happen, correct?
I didn't see the ball make contact.
And despite not seeing it and not seeing a video, you still decided to issue a citation that day, correct?
I think I made the right decision.
I want to talk about why you might have issued that citation even though you hadn't seen the event. This isn't the first citation that you issued to Mr. De Silva, is it?
No, it's not.
You issued a citation to Mr. De Silva for the socks that he was wearing one day, right?
He broke the rules. He had a logo that was far too big. It's a rule violation.
It's a rule that usually you don't ever notice.
I mean, that was probably like the only instance I've seen that happen, but that's just, I don't see people have that big of logos on their socks.
Well, it's a citation that most often you wouldn't even bother to give someone, correct?
I mean, I think it's something you have to be looking at the player very closely for, and I monitor Mr. De Silva closely.
I appreciate that, Mr. Dunkirk. My question was different. Citing someone for their socks logo is not a citation that you would typically issue to a player, correct?
Socks are typically not in violation. Yes, correct, I agree.
If you saw another player with the same citation, same violation of a wrong logo, you would not issue that citation, correct?
Don't say that I would not, but I do acknowledge I look at Mr. De Silva more closely than other players from his previous behavior.
Right, you hold Mr. De Silva to a higher level of scrutiny than any other player, correct?
I hold him to the same rules, but I watch him more closely.
So that's a yes to my question. You hold Mr. De Silva at a higher level of scrutiny than other players.
I guess that's fair, sure.
Mr. Dunkirk, you're familiar with the Eureka Open Rulebook, is that correct?
Yeah, of course.
This book governs your actions as a chair umpire, right?
My actions, players' actions, yes.
You're on permission to approach the witness with what's been pre-admitted as Exhibit 6.
Okay, yes.
You're on permission to publish to the jury.
Yes.
Okay, if we could put page 26. Oh, no. Mr. Dunkirk, I'm going to direct your attention to page 26, section K, B.
You have a copy for the part? Thank you.
According to the rule book, the chair umpire must only oversee matches for which you can be totally objective, right?
Right, you need to act according to the rules.
You can make all decisions free from bias.
Yes, you should remove your bias.
Mr. Meany, you can go to the second page, Exhibit 6. Go down a little so you can see that top paragraph. You as a chair umpire have to be totally objective, unbiased with respect to a particular player, correct?
Right, you need to apply the rules as they are.
And if you can't be fair and impartial to all players, then you have to inform the chief umpire before the start of the match, right?
That's right.
You didn't inform the chief umpire before the start of the match on September 3rd that you hold Mr. De Silva to a higher level of scrutiny than other players, did you?
No, but I don't think that means I can't act objectively.
Thank you, Mr. Dunkirk. I have no further questions, Your Honor.
Anything on redirect?
Yes, very briefly.
Thank you.
Mr. Dunkirk, there was a lot of talk, you can actually do that. There was talk about this particular exhibit for one part wasn't mentioned. Can you explain to the jury what section NC reads?
Yeah. So section NC it's about ball abuse, and essentially a player should not recklessly, violently, dangerously, or in anger hit the ball. Now, this is very dangerous. You know, these balls can be hit at very high speeds and injure anyone that's in the area, so you have to be careful.
No further questions.
Thank you.
Mrs.
Sir, you
Williams?
may step down, please.
Thank you.
Witness be excused from the room.
Yes, sir.
Okay, any objection to excusing witness from the room?
No objections, Your Honor.
Okay, you may remain in the courtroom.
At this time, Your Honor, that the, close our case as the plaintiff, we do rest at this time.
Okay, great, thank you. You all want to take a quick break before we begin the defendant's case in chief?
Yes, Your Honor.
We have more, let's go back to the courtroom by the range or the.
I just, I was happy to see, so I didn't remember. So I see you.
Are you traveling with the team to Sharp Beach? Oh,
Because I've been doing, I've been helping them basically prepare for circuit, so I'll come to get their work coach, yeah, they can also then the coach, but since I've been doing the minimum training, I have just been kind of filling with the more training, if I told you that I had, he did a film clinic that was on paper. That was it.
no.
And then the few things that were in clear for text on, were saved to a page on, so that they down. So like the stuff that she's all. That was what it. Completely everything. So I haven't had much time to.
Yeah, no, my command is right now, the teacher runs all these trial classes. Weekend, probably several classes, but otherwise I just go. But I would teach her like the trials and options myself. I think. So I think it's.
I could do it. And I'm gonna tell you, even when we call the true challenge, is the joy is on people that we. I do it Thursday. But like, when you look at my state work, don't think they're gonna be important. You explain to them how to cook. And then you should know the strong and greatness. Choose to be. Give them a road. And then, like, preserve your memory, all that kind of stuff. You just like, it kind of gives them something. They don't miss. Everyone's doing that.
Feeling great.
And they don't fear it as much afterwards.
So is Tim, so you're back to Shark Beach thinking, is Tim the coach? He's a regular coach?
Where are they traveling to?
Fort Lauderdale.
I think it's that he was signed to somebody. Now, sometimes if the person coach, so the difference.
Okay. Yeah, we're coming over to South Texas to do scrimmage Saturday. We're gonna do a full dress rehearsal. Go back to back. So ideally, I told him. We were there together last year. Yeah.
Was he there last year?
He was.
Did he make his son? Because I know that one of my students, they used to stays for the cloud portion of the planning. So he's like, really good. They were kind of effects with him. So, that's how I'm thinking maybe with time he wasn't, but if he went last year, they're probably gonna miss.
That's a good time. So look forward to it every time we scrimmage with the team, especially both sides. But when we get there, we have this camaraderie.
And it is students, I like. No, I know. In my experience, a team, I'm very old school. And so, I'm trying to, it's the easiest thing you can do is learn the audience, like pay attention to who the judge is. You're saying nothing, right? Here's your room, right? And so, I don't know, at the beginning of the teaching, everyone's going to do it. You know, like, when I started teaching, we want to give a lot of invitations out of 10 to get, they're getting the show all over the place. So if you're in the South, you're just, so you have different things that you're in. So you got the trigger. So sometimes, a matter of learning just hasn't gone well. That's, I just, this is like a passing, some people, sit on the floor. I do my job.
Yeah, no, I'm reading that problem, I'm coaching, see if I can give some insights.
You know, I did a mock trial a couple of weeks ago. For some middle school kids. And.
Anybody get water?
It was so
More than good.
awesome. She's 12.
Wow. See what I did.
You're saying it doesn't that you have these ideas. You know, even if it closes, you ain't clocking up in this is my highlight. This is pro. I would. And so I just, and that kind of stuff, you know, you know, some of the persons, she's so,
Right. It's become a part of who she is, right?
exactly.
Sure.
God, good job.
You go get a handle.
I guess I'll get out too, so y'all can talk freely.
Yes, yes.
So what?
There's so much.
Do any of the attorneys need water? Do y'all need more? Y'all good? Or the Alex, either of you need a bottle of water or anything?
Okay, thank you so much.
Thank you.
Just checking.
Yeah.
Can I ask a quick question? I know that Emma and I were ruling about getting into the injury. The ruling was we could talk about what the injury was, right?
She changed her mind. She sustained on
The
type of
radar,
injury.
right?
That's my understanding of the most recent sustain.
Yeah,
That's what I found out.
okay.
I think they're about to head back.
All right, it's United Business back in session as soon as the judge comes out. There she goes.
By the way, you know your lights out, right?
Which one?
This one back here.
Tom? Nope, never noticed.
All right, so I'll go ahead.
All right, do we miss the
Oh,
judge?
wait,
We're missing Billy.
Hold on, wait for Mr. Durham.
Okay, hold on.
Coming
Oh,
down.
Billy.
Coming.
Like, we're missing Billy.
All right, let's all go ahead then and have a seat.
Your Honor, quickly before we begin, may we clarify, your ruling on the motion to eliminate, outside the presence of the jury?
You mean the jury I just walked into the courtroom and was now excused so that we can have a conference?
I apologize, Your Honor, may we do it constructively? Yeah. Thank you. I believe in prosecuting, you had mentioned the motion in limine about getting into the injury because the injury has been stipulated to. However, our understanding of your ruling was that we are allowed to talk about what type of injury it was, specifically a broken larynx. We just want to make sure that that is still your ruling.
Okay, I said that you can talk about the fact that he was injured, okay, but we weren't getting into it any further than that. Okay? Thanks. Defense ready to present their case.
Defense agreed.
Okay. Make way for witness.
Judge, defense called Devin Quantis to say.
Thank you. You said Fuentes?
Quantis.
Fuentes.
Oh, yes, Judge.
Mr. Fuentes, you may join me here to my right. Please watch yourself coming up. You'll raise your right hand. You solemnly swear that during this U of H tournament that you promise that you'll do the very best for your team.
I will do very best.
Thank you. Have a seat. Okay. Mr. Haney, you may proceed.
Good afternoon, sir. Could you please introduce yourself to the jury?
Yeah, good afternoon. My name is Devin Fuentes.
you tell the jury a little bit about who you are, sir?
Yes, I'm a, well, former tennis player. Currently, I'm a ball boy for Mr. DeSantis, or not ball boy, apologies, hitting partner for Mr. DeSantis. Basically, I help him warm up. I engage in scrimmages with him. I basically train with him.
So as part of your hitting partner relationship with him, have you ever been any kind of matches, anything like that?
Oh yeah, I travel with Mr. De Silva wherever he goes. Essentially, any tournament he attends, I go with him. I help him warm up, I help him stretch. If he wants to scrimmage, we scrimmage. I'm essentially part of his traveling team, I guess.
Did you help him prep at all for the Eureka Open 2023?
I did.
Did you attend that tournament at all?
I did, yes.
Tell us a little bit about what you saw at that tournament.
Well, originally, the match or the tournament was going pretty well up until a certain match. It didn't start too well for Mr. De Silva. He was starting to struggle, get a little flustered, get a little frustrated. And that's when he was bouncing the ball back to what he thought was a ball boy, he accidentally hit a line judge.
Objection, Your Honor, speculation as to what the defendant thought.
As to whether defendant.
As to what the defendant thought.
Yes, to state.
We'll go ahead and shift gears. We'll go ahead and talk about what you could see from your position. So before we get into that, where exactly were you sitting in the stadium?
I was in his player box. It's where everyone on his team basically sits to watch the game.
If I showed you some photographs and diagrams, you'd be able to verify them for us?
Yeah, sure.
Judge, permission to approach the witness with what has been pre-marked as Exhibit 1.
Okay, thank you.
Mr. Fuentes, I'm going to go ahead and hand you a copy of Exhibit 1. Send it to a president.
You have a copy for the board? Thank you.
Mr. Fuentes, could you tell the jury what we're looking at here?
This is a diagram sort of like a tennis court.
Are you familiar with this?
Yeah, I play tennis. I'm pretty familiar with the layout of court.
Okay. Is the photographic elements, the depiction of the court, is that a fair and accurate depiction of a tennis court?
Yeah.
And those words depicting the objects in that diagram, are they true and correct?
Yeah, I would say that in terms of what they're depicting are correct.
Judge, at this time, to admit Exhibit 1's evidence.
Okay, is there any objection to defendant's exhibit 1?
No objection, Your Honor.
Okay, defendant's exhibit 1 will be admitted into evidence.
Permission to publish Exhibit 1 to the jury.
Grant.
So. Now, could you describe the positioning of these officials on this diagram?
Sure. So obviously you've got the chair umpire sitting in the middle. They're the ones that are kind of raised high above. You see them on TV. They're the essentially head official. They're the one making the final call on everything. And then to the side, you've got line judges. Those are the people that are actually responsible for determining when the ball's correctly in play or not. If you've ever got sort of like a dispute over whether or not the ball was in or out, those are the people making the initial call. And to the side, you've got the ball crew. Those are the people that hold all the tennis balls not currently in play. Typically, when you're not serving, you usually give the balls to the ball boys because you don't want them in your pockets, like weighing you down. The only people that sort of carry the balls with them is the person who's actually serving.
Mr. Fuentes, to clarify, you see where it says line judges right there on the left-hand side?
Yes.
You see how those lines are identifying those two individuals?
Yes.
Line judges? So that person right under that bottom line judge, who would that person be?
That person would be a ball boy according to the differentiating colors.
Judge, may I approach the witness with some pre-marked Exhibit 7?
Yes.
Judge, please go. Mr. Fuentes, I'm pretty much Exhibit 7. Now, without going into the contents of Exhibit 7, do you recognize it?
I do.
What is it?
This is a photograph of the court from the day that Mr. DeSantis was playing at the Eureka tournament.
And how are you familiar with it?
Well, I mean, I was there. I've also seen this photograph preparing for trial today.
Would you say that's a fair and accurate depiction of what you can see that day?
Yeah, I think it's exactly what I saw.
Judge, at this time, I'm going to admit Exhibit 7 into evidence.
Is there any objection to defendant's exhibit number 7?
No objection, Your Honor.
Defendant's exhibit 7 will be admitted into evidence.
Permission to publish exhibit 7 to the jury.
Yes.
Mr. Fuentes, we'll go ahead and talk a little bit about those staff members on that wall. Could you help us understand what we're looking at here?
Sure, so this is kind of a actual version of the diagram I talked about earlier. So the guy in the upright chair, the big chair, that's the umpire. He's the one who's in charge of making all the calls. And then in the back, you've got ball boys and line judges.
So we'll go ahead and talk a little bit about the appearance of each of these. What are each of these officials wearing?
So that's what was a little bit confusing on the day in question. Typically, ball boys and line judges have very different uniforms. I mean, every tournament I've ever been to, that's been the case. It's very easy to distinguish them. But at this tournament, the Eureka Open, they were actually wearing almost the exact same uniforms in terms of the colors. The shirts and the pants were the exact same.
And to help the jury clarify, have you seen any other tournaments where uniforms like that is standard procedure?
Not that I can recall. Pretty much every tournament I've ever been to, it's been very easy to tell the difference.
Mr. Fuentes, earlier you mentioned that there is a chief umpire of sorts. Can you identify him for us?
Yeah, that'd be the guy in the chair.
And who is that?
His name is Kelly Dunkirk.
Was Kelly Dunkirk the chief umpire during the Eureka tournament?
He was for this match.
For this specific match.
Yes.
Tell us a little bit about what you could tell from your perspective was going on.
Well, I know Mr. Dunkirk actually pretty well. Like I said, I've traveled with Mr. De Silva for most of his tournaments, and this isn't the first time we've had issues with Mr. Dunkirk.
Tell us a little bit more about that.
Well, it's kind of, they have a difficult relationship, I want to say. There was an instance where Mr. De Silva was cited very unfavorably for a very, very minor rule violation back a couple of years ago that everyone thought was just crazy.
So I want to go ahead.
Objection, Your Honor, as to speculation, has this witnessing what everyone thought.
It's sustained.
Yes, sir.
Your Honor, we would ask to strike that testimony.
So I want to go ahead and get into the specifics about that rule violation you just mentioned. What was it for?
It was for his socks.
And can you elaborate a little bit?
Well, yeah, I mean, it was kind of nuts. He said that the socks were not in regulation of the code. I've never seen anyone been cited for that before. I mean, I thought it was ridiculous. Everyone I knew thought it was ridiculous. It was ridiculous.
Sorry, Your Honor, again, I'm gonna have to object to speculation as to what other people thought.
Yep, it's sustained.
What was your impression personally for the reason that he was cited?
I'm sorry, re-ask the question?
What, Mr. Fuentes, what was your personal interpretation as to why he was cited?
I mean, he was cited for a supposed rule violation, something I've never seen before. I have no idea why.
Do you have any personal opinion on why that the citation was issued?
I mean,
Objection, Your Honor, calls for speculation.
How common is a citation for socks in the sport of tennis?
I've never seen it. Like, this is the only time I've ever seen it in my entire career. It's the only time I've seen it since.
Thank you for your time, Mr. Fuentes. No further questions, Chair. Pass the witness.
Thank you. Cross-examination?
Yes, Your Honor. May I proceed?
Yes.
Now, Mr. Fuentes, in your own words, this is a stupid trial.
What do you mean?
I'm asking you in your own words.
I don't know what you mean. I'm sorry, I don't understand.
Have you ever stated that this was a stupid trial?
Maybe?
Possibly, okay.
Yeah, I'm not sure.
Have you also stated that you want this trial to end as quick as possible?
I mean, yeah, no, this isn't exactly how I want to be spending a Sunday evening.
Right, because you think this is all just over dramatic.
I don't know if I would say it's all over dramatic. I think that certain elements of it are.
Permission to publish exhibit 5 to the jury.
Grant.
According to you, Mr. Fuentes, would this be considered just dramatic to you?
I don't know exactly what I'm looking at.
You don't recall the plaintiff?
I'm not just seeing it. That's what I'm saying. It's not in front of me.
Okay. Well, the fact that the plaintiff was
Just
in,
look at the screen, right there.
Oh, sorry, it's down. Can I move it?
Yeah.
Okay, there we go. Now I can see it. Sorry, I didn't see it.
okay, is that just dramatic to you?
I don't know really what's going on here. From what I remember, this is, I believe, I'm sorry, I can't remember her name, but, or his name, but I believe back there, on the day that this happened.
Mr. Fuentes, according to you, everybody had it out for the defendant.
I think a lot of the tennis world did, yeah.
And, you know, you would say that jealousy just comes with the territory, in your own words.
I mean, I think that, yeah, Mr. De Silva, because of his status, has brought out some bad elements in people, who are looking to kind of pinpoint him for certain things.
Right, and that's why you think this is all just a money grab.
I would say that that's part of why I'm like a little suspicious of it, but I also have my other doubts about certain things from what I remember.
You yourself are paid very generously by the defendant, correct?
Yes, I'm paid by Mr. De Silva.
Because you work for him.
I do.
Okay, I believe you said during the rec that you're his ball boy.
I was a hitting partner. That was a misquote on my part.
Okay, and that's why you're here testifying today.
I was told to be here.
Right. The defendant himself is not here.
I know he's not.
No further questions.
Thank you. Anything on redirect?
Yes, that's pretty much
Very
that.
brief.
Before I proceed, Judge, you have to visit by rebuttal.
Yes.
Mr. Fuentes, very briefly, do you recall what happened after the line judge was hit?
I believe that at a certain point they got up and they left.
Are you able to identify any tennis players in this photograph?
Yeah, that's Mr. De Silva bent down, talking to them, not the guy with the mask.
Did you see Mr. De Silva doing anything after the line judge was hit?
Yeah, we went and visited them in the hospital later that day.
What about in the immediate moment?
They offered their condolences that they were sorry.
No further questions, Judge. I simply ask this, the excuse.
Thank you. Is there any objection from excusing the witness from the?
No objection, Your Honor.
Any objection?
No objection, Your Honor.
Okay. You step down and you can remain in the public. Finish to call the next witness.
Your Honor, at this time, defense calls Peyton Hewitt to the stand.
Thank you. Mr. Ewan, if you would join me here, please, to my right.
Yes, sir.
So watch your step coming up. And if I can get you to raise your right hand, please. You solemnly swear that as a member of this U of A's mock trial team, you are going to do your very, very best and testify for the defense.
Absolutely.
Okay. Proceed.
May I proceed, Your Honor?
Yes.
Good afternoon. Would you please introduce yourself to the jury?
Hello, my name is Peyton Hewitt.
And Mr. Hewitt, what is it that you do for a living?
I am a sports analyst and statistician.
What does it mean to be a statistician and analyst?
So I work for the International Tennis Association, also known as the ITA. And part of what I do there is I am their head statistician, and I look at various tennis statistics and also player in game statistics.
Tell the jury, tell us a little bit about how you got into this field and how you got into this job of working for the ITA.
Sure. So I initially got my bachelor's in statistics from Madison, Wisconsin. And then I went back there and got a master's in both statistics and sports administration. For the past 15 years after that, I worked various jobs, and now I'm at the ITA where I am the head statistician.
Mr. Hewitt, were you asked to give an opinion in this case today?
Yes, I was.
And without going into the contents of your opinion, did you come to one?
Yes, I did.
Coming to that opinion, did you base it on that experience you just talked about, your education, and your knowledge as a statistician?
Yes, I based my opinion both on my experience that I have had previously and the information I was provided about this case.
Do you believe that you had sufficient facts to come to an opinion?
Yes, I do.
Do you believe that you based your conclusion on reasonable and reliable principles?
Yes.
Do you believe that you reasonably applied the principles, your background, and your field to the facts of this case?
I believe I have, yes.
I'd like to get into your work in this case. What did you review?
So I reviewed all of the statements that were provided to me, and I believe I was provided all the exhibits in this case as well.
And after reviewing the case and all of the materials that you were provided, what is your opinion?
So my opinion is twofold. One is on the procedures that the ITA has for protecting line judges, that it's not sufficient. And then also specifically when it comes to the match that I was brought about in this case, that the incidental hit wasn't purposeful based off of the ball velocity.
All right, I want to start with that first opinion. You mentioned that the procedures of the ITA don't do enough to protect line judges. What did you review that indicated that to you?
So the ITA has kept a record of the number of injuries per year that happened to line judges ever since 1990. So I collected and compared all of the incidents, and then also compared them to policy changes that the ITA has done specifically to try and keep linemen safe.
So how common are injuries to line judges in tennis competitions?
The average is it happens about 6 times a year, but that the statistics that I reviewed indicated that this is a trend going upward, and there are certain reasons for why that trend is going upward.
What are some of those reasons for why that trend is going upward?
It really has to do with the growth of the sport. So tennis, the athletes are in better shape. The material that's used in the tennis balls and the material in the rackets is improving to make the ball go faster. And with the increased velocity of the tennis ball, there's increased risk.
You mentioned policy changes that the ITA is trying to implement. What are those policy changes?
So about 1970s, there was a policy change that required line judges, instead of being sitting down, to be standing while they're doing their judging. This is so that they can be more active and mobile and potentially move out of the way of incoming tennis balls.
Have those policy changes made a difference in the statistics you find when it comes to injuries?
No.
Now, you reviewed the facts of this case, right?
Yes.
And did you review the actions of Cam Gardner, the line judge in this case?
Yes, I did with the video that was provided for me.
Do you believe that he was active and alert on the court as he should have been pertaining to the policies?
Based off of what I reviewed, the video indicates that he is standing still and not paying attention. This is contrary to the policy. The whole reason that line judges aren't sitting down is that so they can be aware and move out of the way whenever a tennis ball comes in their direction.
I want to talk about that second opinion you mentioned, that this was an accidental hit.
Yes.
What did you review that made you believe that?
So that, it's really two different things. So one, I looked at the video of the incident frame by frame in order to break down exactly how fast the tennis ball was moving. And then I also compared the speed that I found from that frame by frame analysis to the seasonal averages of 2023 for his forehand, which was the hand that he used to hit the ball, which is your right hand.
All right, I want to break that down a little bit. You said that you used frames of a video to calculate the speed that the ball was going. Did you create any kind of product that shows this analysis?
Yes, I have a breakdown of the court and exactly how I came to the determination of the speed, specifically by using different parts of the court that are standardized to determine the speed of the ball in this case.
Would you recognize a copy of that still image of the court that you just mentioned if I showed it to you?
Yes.
Your Honor, permission to approach the witness with what's been pre-marked as Exhibit 8.
Okay, you may.
Mr. Hewitt, do you recognize Exhibit 8?
Yes.
What is Exhibit 8?
So Exhibit 8 is the breakdown that I did of a still frame of the image to figure out exactly how far the ball traveled.
Is this a true and correct copy of the breakdown that you performed during your analysis of this case?
Yes.
And is it the same as when you last reviewed it?
Yes.
Your Honor, at this time, defense moves to admit Exhibit 8 into evidence.
I'm really sorry, I can't admit anything into evidence. I don't have a copy of it.
Yes, Your Honor.
Is there any objection to exhibit number 8?
No objection, Your Honor.
Exhibit 8 will be admitted into evidence.
Your Honor, permission to publish Exhibit 8 for the jury.
Granted.
Mr. Haney, do you mind? Thank you very much. All right, now, Mr. Hewitt, I want to talk a little bit about Exhibit 8 and the work that you did in analyzing the court. What distance did you calculate that was between Mr. De Silva and Mr. Gardner?
So that was 39.7 feet. You want me to break down how I got there?
Absolutely.
So if you look at the right side of the image, you'll see that I have that marked down as 18 feet from the baseline to the volley line. That's because 18 feet is the regulation standard for how far that distance is. Because of that, I can use that to figure out the angle of the frame and how far other distances are on the picture. And whenever you compare the relationship between the two, that's whenever you can figure out that the distance that I need to calculate is 39.7 feet.
After you calculated the distance, what did you do next?
Then I did a frame by frame analysis to figure out exactly how long it took for the ball to travel.
How did you do that?
Basically, well, each frame is a certain amount of time passing, depending on the frame rate of the camera. And you can count the frames that it takes for the ball to travel, and then you can use that to calculate how long it took.
When you performed that calculation, what did you find?
I found that the ball took 0.55 seconds.
And what is the significance of 0.55 seconds?
Well, it lets me calculate how fast the ball was going, because in order to calculate velocity, you need to know the distance it traveled. You also need to know the time it took to travel that distance.
And did you perform that calculation?
Yes.
And what speed did you find?
So whenever this is in feet per second, but whenever you convert it to miles per hour, the velocity of the tennis ball was 42.9 miles per hour, or 49.2 miles per hour. My apologies.
Once you found that the speed of the ball was 42.9 miles per hour.
I'm sorry, I misspoke on my testimony. It's 49.2.
Thank you. Once you found out that the speed was 49.2 miles per hour, what did you do with that information next?
So then I then compared it to his average forehand in top forehand speeds for the 2023 season. I did this because the ball in the recording was hit with his right hand. Whenever you're playing tennis, your right hand strokes are considered your forehand strokes. So I wanted to compare those to see just how fast or just how much of a difference there was to the balls that he normally hits.
And was there a difference between this hit and the balls that he normally hits?
Yes, the top speed for the 2023 season was 102 miles per hour, and the average speed was 81 miles per hour.
So how does the hit on September 3rd compare to how Mr. De Silva usually hits a forehand?
Mr. De Silva hit this ball roughly 30 miles per hour slower than his usual strokes that he does.
And what is the significance of that 30 miles per hour slower to you and your opinion?
It goes to whether or not this was intentional.
What do you mean by that?
Well, whenever you hit a ball and you're trying to get it to someone on the court, like either like a ball boy or just to move it out of the way, you're not going to hit it with the same intensity if you're trying to hit somebody. Now, based on this case, it looks a lot more, it looks more like an accident comparing the speeds.
Thank you, Mr. Hewitt. I pass the witness, Your Honor.
Thank you. Cross-examination.
Yes, Your Honor.
May I proceed?
Yes, please.
Mr. Hewitt, you're not subpoenaed by the court to be here today.
I am not.
You were hired to be here,
That's correct.
and you're hired by the defense attorney in this case.
Yes.
So they are paying you for your testimony today.
I wouldn't say that they're paying me for my testimony. They're paying me for the work I did and to testify about that work.
Right, so you're being paid to testify about your work in their defense, is that correct?
Yes,
And that payment that you're receiving is about $15,000.
that's
Right.
correct.
And in addition to that, you have an agreement with the lawyers, the defense lawyers in this case. Is that true?
Yes, that agreement is that I actually cut my usual fee for testifying in half. And in response, there's going to be a promotion of like a social media page that I have.
Now, I appreciate that, and I want to talk about that promotion on social media. It's true that if you and the defense win this case, you receive an additional bonus of social media promotion. Isn't that correct?
I don't think any of my compensation for testifying is contingent on winning this case.
Mr. Hewitt, is it your testimony today that you do not receive a bonus of social media promotion in the event that the defense wins this case?
I believe that's correct. I believe that my testimony today, the bonus is just for testifying. It's not about whether or not we win or not.
Do you remember writing a report in this case?
I did.
Would it refresh your recollection if I were to show you a copy of that report?
Sure.
At this time, Your Honor, I'd like to approach the witness with his report. Now, if you can just go ahead and look at the bottom of that second paragraph and read it silently to yourself. Provide the court a copy. Yes. Looking at lines 15 through 17 of the second paragraph. Have you had a moment to read it?
Yes.
And is your memory refreshed?
Yes.
Now I want to ask you one more time. Do you receive social media promotion in the event that the defendant wins this case?
Yes, I was mistaken.
Thank you, Mr. Hewitt. Now I want to talk to you about the two opinions that you gave in your report. One opinion was that this injury or injuries to line judges are unavoidable in tennis. Is that correct?
Yes.
Now, you'd agree with me that this injury to Cam Gardner could have been avoided.
What do you mean?
Well, let me explain, Mr. Hewitt. If Mr. De Silva, the defendant in this case, hadn't hit the ball towards Cam Gardner, you'd agree with me, there would not have been an injury to Cam Gardner.
I agree. And also, if Mr. Gardner would have moved out of the way, there also wouldn't have been an injury.
So it would have been avoidable.
Yes, if the ball was not hit, there would be no injury.
Thank you. I want to talk to you about your second opinion in this case, which is that the ball that struck Cam Gardner was not hit with Nico De Silva's full strength. Is that correct?
That's correct.
You'd agree with me that although the ball was not hit with Nico De Silva's full strength, it was hit at a relatively high speed.
Yes, tennis balls do move at a pretty high speed. They're a fairly light object. So pretty much any time a professional is going to make contact with that racket, it's going to come off at a high speed.
Right. And the speed with which Nico De Silva's ball hit Cam Gardner in the throat was 49.2 miles per hour, correct?
That's correct.
That's what Mr. Adams.
No redirect. Sorry, Your Honor, no redirects. We just asked this witness to speak.
This is right, thank you. Maybe be excused from the invocation.
Yes, sir.
Yes, Your Honor.
Is an important. We have our next witness.
Beth has no further witnesses. The rest are case.
Great, thanks. Do you all want a recess before we close?
Yes.
Okay, 5 minutes. It's 4:10. I'll see you back at 4:15.
Oh. Just spill my water again. Should we go out? I'm gonna keep it over. Fred Williams is gonna come after. Yeah, I know,
Right.
yeah, I know. I say that.
Oh, okay. Sorry.
I'm really there, I didn't mean to share the weekend, but it's Super Bowl square. Why do I want lots of it? They dirty, what do you guys do for that? Good, you can't the fun. Yeah. Yeah. I should have been more. You were reading? I learned something.
I don't really have classes on. But I'm.
What about like earlier?
Monday, we learned at any time.
I knew you very well. Let's see what's up. it's a personality. I got this out.
Essentially, that's the one. Yes, something about
Right, and so that's just important to articulate because there's facts here that we expect to be valuable. These cases are in the fashion, so we're going to make their release. We see all this and as a next level now. So that's. Yeah, and, you know, stop there and that's.
That's cruise control. What was that? Okay.
Just, yes.
Like 10. I would say it's just.
If you choose to
All right, you ready?
Yes, Your Honor.
All right, let's all go ahead and be seated.
I'm so hungry. I'm so hungry.
Okay, breaks the close.
Yes, Your Honor, and now reserve 2 minutes for one.
How much time do you have to begin with so that I know that we're reserving two?
Way too much, yeah, we got.
What?
Way too much.
Way too much. Well, if you have way too much time, I don't think I need to be reserved.
Thank you.
But maybe I should. All right, you may proceed.
May it please the court.
Yes, of course.
He knew the rule. He broke the rule. And he injured Cam Gardner. Ladies and gentlemen of the jury, throughout this trial, you've heard a lot. Before I get into this closing, I want to specifically talk about the law, which is the reason why we're here today. As the plaintiff, the first thing we must prove is that the defendant acted so recklessly that his conduct was entirely outside the range of ordinary activity involving professional tennis. I want you to keep in mind that word reckless. And just so we're all clear to start off, we're going to talk about the definition specifically. It says the defendant acted with recklessness if he knew it was highly probable this conduct would cause harm and he knowingly disregarded this risk. I want you all to keep that in mind. Now, being that throughout this trial you've heard a lot, instead of just getting up here and tell you what I think or what I believe, let's talk about what you heard throughout this trial. Now, first you heard from the plaintiff himself, Mr. Cam Gardner. And Mr. Gardner told you about his past as a line judge. This is something he does, and he does it pretty well. But he told you on this specific September date, the defendant became upset. He became upset because he wasn't winning. Right after coming upset, he stared intensely at the plaintiff. Not even minutes later, the plaintiff was injured. Now, I want you to keep in mind what you heard from Mr. Dunkirk. Mr. Dunkirk is an umpire. And he let us know that he saw the aftermath of this occurring, but he also let us know that he had given violations against the defendant twice that day. He also let us know that this wasn't new for the defendant, who many times get angry. He injured people before in the same type of way. Now, I want you to think about their testimony overall. Very clear. Story didn't change. Very concise, straight to the point. They told what they knew, what they remembered, and that was it. I want you to think about who the defense called today. Now, from the defense, you first heard from Mr. Fuentes, who believes this is a stupid trial. He admitted to it himself. He doesn't know why he's here. But I will say at first he acted as though he doesn't even know what the word stupid means. He considers this to be a joke. He's not taking any of this seriously. Not only that, he made sure that he said he believed this was a money grab. But ladies and gentlemen, it makes a lot of sense because he's getting money from the defendant. So the money that he receives, he doesn't want to take it away. He testified on the stand that he is the defendant's ball boy, and he takes that role very seriously. So anything that could possibly jeopardize the money going into his account is stupid. It's a joke.
That's not the only person you heard from the defense side. You also heard from a supposed expert, which I'm still not really sure what he's an expert in, maybe TikTok. But I want you to keep in mind during this expert's testimony that he immediately started to stutter when even the mention of a bonus was brought up. And his testimony changed while he was on the stand as well. My co-counsel asked him, "Sir, you will receive a bonus if the outcome in this case is in favor of the defense." And he stuttered for a little bit and he responded, "No, that's not true." But he was quickly reminded, based on his own statements, and then his testimony on the stand under oath changed. Not at all credible. This is somebody whose TikTok following could be jeopardized by the plaintiff receiving what's rightfully hers. Somebody whose TikTok following could be jeopardized by the defendant being held accountable. Now, I want to make this very clear. Everything you heard during opening, everything you're hearing now during closing, when I sit down, what you hear from opposing counsel, it's not evidence. What is evidence is what you heard throughout this trial. What is evidence is what was said on the stand by the witnesses. And I want you to keep in mind the credibility of each witness that you heard, who has a stake in this trial, whose livelihood or TikTok following is contingent upon this trial. Now, ladies and gentlemen, I want to go back to the definition of reckless I talked about a little bit ago. It says the defendant acted with recklessness if he knew it was highly probable that his conduct would cause harm and he knowingly disregarded it. Conveniently enough, the defendant didn't show up today, but we did get the defendant's words in through the plaintiff. And one thing he said the defendant said was, "There's always a chance you could hurt somebody that is on the court." He was aware. Let's compare. Conduct caused harm and he knowingly disregarded this risk. There's always a chance you could hurt somebody that is on the court. He was aware. That in and of itself, which is the defendant's own words, lets us know that he was reckless. But that's not all. We also got through the plaintiff's testimony that the defendant said, "I have worked hard to better control my emotions," which lets us know in that moment he wasn't controlling his emotions. These are the defendant's own words. Did my emotions play some part in this? These are the defendant's words. Yes, it's possible. And the last thing you heard from the defendant, not through the defendant, but from the plaintiff, obviously I can be more careful. There was no need for me to hit the ball that hard, especially without looking where it is going. Ladies and gentlemen, that is reckless. As I just read out the definition to you all, it is clear and cut and dry as that. Now, I anticipate opposing counsel may try to get up here and go on for however long, trying to point doubt and excuses here and there. But we're here to determine whether this man was reckless. And based on the evidence that you heard, he was. So let's go directly to the jury charge. The first question that you will be asked is, did the defendant either intentionally or recklessly injure Cam Gardner that his conduct was entirely outside the range of ordinary activity involved in the sport of professional tennis? He's a pro. He's a professional. Nevertheless, so not too far from him at all, he hit directly. He's a pro. He's a professional. Nevertheless, he was reckless in what he did. Out of the ordinary for someone with his profession, with someone with his skill level. So for that, you will answer yes. And the second question you will be asked is, was the defendant's conduct a substantial factor in causing harm to Cam Gardner? Ladies and gentlemen, but for the actions of the defendant, we would not be here today. Mr. Cam Gardner would not be injured. And I don't think that's been disputed throughout this entire trial. I don't think no one said that he's not the reason that the injuries were sustained. So based on that, ladies and gentlemen, you will also select yes. Ladies and gentlemen, we do not ask you to leave your common sense and everyday reasoning at the door. We want you to bring in your everyday life experience. It's a clear-cut case. He knew the rules, he broke the rules, and he injured Cam Gardner.
So what will you be doing closing for the defendant?
Yes, Your Honor.
Proceed.
May it please the court.
Thank you.
Not every story has a villain. Members of the jury, before I go any further, I want to acknowledge something that the defense has not disputed all day. And that's that the fact that this injury happened is unfortunate. You didn't hear words from Mr. De Silva, Mr. Fuentes, Mr. Hewitt, or any of us on defense counsels dispute that this event is unfortunate. But what we've shown you throughout trial is that not every villain story has a villain. And sometimes things just happen. On September 3rd, many people voluntarily chose to be at a tennis tournament. Two of those people were Nico De Silva, tennis champion, passionate player, and Cam Gardner, a volunteer line judge who's passionate about tennis, passionate about judging the line, passionate about the sport and being. And when Mr. Gardner stepped into the tennis arena on that day, he brought with him some knowledge. Knowledge that he's learned over many years of being a line judge. The knowledge that balls are going at really high speeds. Knowledge that sometimes line judges, unfortunately, get hurt. Knowledge that he's had friends who are line judges who have unfortunately been hurt. And knowledge that when you walk on the court in a professional tennis match, there's always a chance that you could be the person that gets hurt. And I don't say any of this to blame Mr. Gardner for what happened on September 3rd, but I say it because Mr. Pierce asked you to be reasonable when he just got up here and spoke with you. And as I walk through some of the evidence and testimony that we've heard throughout this trial, I ask you to think about the reasonableness. Mr. Gardner, how could it be reasonable for Mr. Gardner to be a line judge, to have friends that are line judges, to have seen injuries to line judges in the past, but somehow believe that this wasn't just an accident? It's not reasonable. Mr. Pierce just got up here and told you that I'm going to come up and talk to you a lot about excuses. I'm not going to do that, but what I am going to do is give you some law. Mr. Pierce told you about what he, Miss Matthew, had to prove today as the plaintiff. He told you that they have to prove that De Silva intentionally injured or acted so recklessly that it was outside the range of ordinary behavior. But they stopped reading there. And Judge Roth is going to give you some instructions in a minute. And part of Judge Roth's instructions is going to be that De Silva is not responsible for an injury resulting from conduct that was merely accidental, careless, or negligent.
And I want to focus in on that word careless. You heard a lot of testimony today. You heard testimony directly from Mr. De Silva. Mr. Pierce got up here and gave you some. Obviously, I can be more careful. You may find, members of the jury, that Mr. De Silva was careless. You might find that. There was no need for me to hit the ball that hard, especially without looking where it was going. You might find that Mr. De Silva was careless when he hit that ball. Obviously, it was unintended to hit someone. Members of the jury, if you believe that Mr. De Silva was careless, that he should have looked where he hit the ball, that's okay. I think Mr. De Silva would agree with you. He should have been more careful. But what the plaintiff has to prove by a preponderance of the evidence is that he was reckless by knowing that his conduct would be likely to cause substantial harm. And you heard no evidence that Mr. De Silva knew or had a reason to know that his conduct was likely to cause harm. He may have been careless. He was not reckless. Mr. Pierce asked you to assess the credibility of witnesses today. I want to talk about the witness who issued the citation on September 3rd, Kelly Dunkirk. He took the stand today to tell you about his issuance of a citation not only on September 3rd, but a citation in the past. A citation where he said to Mr. De Silva, I'm issuing a write-up because your socks aren't right. And you got a chance to hear from a former tennis professional who's around this sport constantly, Mr. Fuentes. And you heard from him, this is not a citation that happens. This is not a citation that is issued. Never seen it happen. Now, why do we think Mr. Dunkirk might issue that citation? Well, he admitted to you. I hold Mr. De Silva to a higher standard, to higher scrutiny. I don't like Mr. De Silva. I don't like him at all. In the tennis rules, in the Eureka Open rulebook, there's a provision that if you can't hold players to the same standard, to be fair and impartial, then you shouldn't be an umpire in the first place. Now, I know that Mr. Dunkirk took the stand and said, yeah, I know I don't like him, and I know I hold him to a higher standard and to a higher scrutiny than every other player that I see, but I can still be fair. And that's not reasonable. If you are going to admit you're going to hold a player to a higher standard than anyone else, that is the definition of being partial, of being biased. Mr. Pierce asked you to not leave common sense at the door. We have common sense understanding of what it means to be fair, and that is not it. Today, Mr. Pierce and Miss Matthew had the burden to show you that more likely than not, Mr. De Silva was reckless. And he hit the ball in the direction of Mr. Gardner. All evidence today has shown that he may have been careless. He might need to have been more careful. But he did not act reckless such that he knew his conduct was going to result in harm. There's no evidence of that. So we ask that you check no. Question 1, did Mr. De Silva act recklessly when you go back into the jury room to deliberate? Not every villain has a story. Story has a villain. Today, you've heard about Mr. De Silva, who rushed to the side of Cam Gardner when he realized where the ball had landed off his racket. Not every story has a villain, and this one doesn't. We ask you to find Mr. De Silva was not reckless on September 3rd. Thank you.
Yes. Now, I want to make sure I quote opposing counsel verbatim. But she said, not every villain story has a villain. Not sure what that means, but ladies and gentlemen, we're not here to determine whether he is a villain. That's not what we're here for, right? Whether he is likable or not, that is not our concern. Opposing counsel has already admitted they don't like him, but that's not why we're here, right? We're here to discuss specifically the law and the harm that was done against this plaintiff. Opposing counsel got up here, said the word reckless, and read many things, but the definition of reckless. And I just want to leave you once again with the entire reason of why we're here. This is the decision you're making. The definition of reckless is if the defendant with recklessness knew it was highly probable that his conduct would cause harm and he knowingly disregarded this risk. That is the crux of this case.
Thank you. Concludes the U of H intramural classic. Thank you all very, very much. I think Judge Reeves is going to get in shortly to collect the scorecard. Why don't we go ahead and take a brief 5-minute recess, and then I think there will be some comments. Here's my. All right, so we'll resume in, I will say, 5 minutes.
Make sure we've got scores everywhere we need scores. Scores wherever we need. Everybody always forgets to learn that. What? Oh, of course. It's messy though, don't make fun.
That's my pen, don't take my pen away
I
from me.
thought you were gonna give me one there. No, I like my very long.
I don't know my pens. Oh, these are my favorite.
My favorite pen.
Oh my God, they're my happy pen.
What?
Like the.
My marker pens.
Marker pens. They write nice and clear. I'm a dork. You know how much I love my big pens.
I love them.
Like the little old school blue big pens that are crystal clear.
Yes.
I used to use those in law school.
I love them
And
too.
my hand was flat.
We use Haley has hers. Oh, scratch Haley. I need about text. I do it right.
You know, because everybody always misses closing that's on the next page. That's why I have to double check.
I didn't miss
You did not.
I'm special. And yes, no.
These seats in the jury box, I think, are actually a lot more cozy than people ever give them credit for, because they can lean back.
They
well.
lean back, yeah. They're
Hard to lean back.
Well, don't, once you know what the threshold is, don't just keep whacking into it.
It's hard. Like mine, you have to really push on it. Like I'm using my core right now.
Good exercise.
Maybe you can like.
See, I would just do this. Like I caught myself doing it earlier. I was like, that's stupid.
I know, I get ADD and I'm like.
Spinning around.
Sorry, shut up.
Who was it? The juror threw up there. Was it your mom?
Yeah.
That was mine.
Mom.
Wasn't it your mom?
Oh, yeah, Judge Roth had a juror throw up.
Yeah, I was
Mom had a
watching
juror
it
throw
on Zoom, and all of a sudden she had like a stomach bug or something.
And tried to muscle through it.
I know the mediation I had in your court yesterday, the poor woman, she just found out she's pregnant. And the whole time, I just felt so bad for her because, you know, she's trying to participate in mediation with, you know, not the attorney, but the plaintiff. And she was just miserable. And I was like, you know, when I was nauseous when I was pregnant, I was like, I really like sour candy. I have some sour candy in my office and bring you some. So I wore heads and I think that helped her work. But
Oh my God, sour candy is great. When she was recovering, we had not she, but the one behind her. We kept
Consent.
we had
I don't know
this
why.
the Jolly Rancher sour candy.
Yeah.
I think it's just the strong,
The gummies.
the strong flavor.
Like I.
The only thing I know I just know her for peppermint spray
Yeah.
from heat exhaustion.
The,
It saved our asses
It is-
on the last hike.
people don't realize it, but that was like one of the best tricks I learned. I'm pretty strict, but I like do stupid stuff like run a lot.
Also go hiking with Tanya, like
Yeah.
in Santa Fe in the middle of the
The
day.
great thing is, a little peppermint oil in a spray bottle with water. When you spray yourself, the menthol, it stays on your skin, so like even just the slightest breeze hits it, it's super cooling. So it is amazing. I'll carry a bottle of it, and like every 2 minutes, I'll be like spritzing as we're hiking, like in the middle.
Oh, yeah, no, it saved our
Desert
ass,
in
it saved our ass in the New Mexico hike.
Just wait on
Yeah, but just when you're hiking there, like when you're already out, or like when I'm running.
Yes, we're just waiting on you.
Not you, I'm also waiting on.
Oh, sorry.
Sorry.
It's okay.
Decisions. Kristen Weaver. Who's Kristen? Okay.
She went to law school.
Oh, she did? Okay, well, I'm part of the lunch crew tomorrow.
She's a couple years over next.
Okay.
She was a SB rep when I was president.
Okay.
Did you listen to the test? Please?
All right.
And not yet, but I need to come out.
We're waiting on one more ballot to be turned
Almost
in.
done.
And mom's like, and the point is, I can still talk though, right? That's what the face is.
Will you get the other team for me?
I sure will.
As long as you get the last one there.
Where does she work these days? Yeah.
No.
Might have done that, so you don't have to do that.
Right, so let me go ahead and begin by saying that I think all today's. My understanding is you got this problem about an hour in. Is that even for the witnesses?
Yes.
I think your witnesses did. For 1 hour prep time. So very, very impressive. I think this is a great way to test your skills because you'll never know how things go in the courtroom. Like, for instance, you were absolutely right when you called me on the limiting. You were absolutely correct, okay? But I wasn't backing down. I should have overruled her objection that I sustained because of the ruling that I made in limiting, and you guys just handled it brilliantly, okay? Okay, the judges are gonna change or make or correct her mistake, that's fine, we'll move on. So, very, very good. All right, I appreciate that. I'm going to ask you all to write down the following and make sure that you memorize this, okay? So that Judge Weems and I, okay, will not have to deal with improper impeachment in the courtroom when you all are in front of us, okay? We're going to imagine the question is, what is your name? And in the deposition, the witness said, my name is Jane Doe. Okay, she gets on the witness stand and you ask her what her name is. She says Jane Smith. Okay, Ms. Smith, let me go ahead and show you your previous deposition testimony. Sworn, under oath, you had the lawyer there, and I asked you, before you do that, please read and review your deposition testimony. Have you read that testimony to yourself? I'm going to ask you again, what is your name? If she says her name is Jane Smith, you read that deposition testimony out loud. Let's go ahead and read what you answered when I asked that question in deposition. My name is Jane Smith. Or Doe, I forgot which one was one. That is how you impeach a witness. The last thing you do is read the deposition testimony. All right? You have to have the question that you ask on the witness, on direct or on cross. It has to be like almost the same or substantially the same as the question you asked in the deposition. Many lawyers will actually read the question from the deposition transcript so that there's no objection that the impeachment isn't the same or similar as? 80% of lawyers get that wrong? Close, Williams?
I would say higher, but you know, you wanna be generous, you could say 80.
So I'm giving you that, so as young lawyers, you will come in and check the box on impeachment. It is it's terrible. Yeah, objection to meeting. Meeting is a real objection. Okay, and when you're on direct, you be letting questions like, do you remember Mr. Silver saying blah, blah, blah? She should be asking, what did Mr. Silver say in that interview? Okay, asking questions, do you remember? And then she read the testimony out is a classic leading question. You need to be objecting to that because this witness would have had a hard time telling you what he said in the interview. All of you, when you hand the witness a document, you need to hand it to the judge. Especially if you want the judge to rule on the admissibility of the document. A good way to remember that is once you admit it into evidence, it's the court's. It no longer belongs to you. And if you still have it in your possession, I mean, you obviously have a copy of it, but the original needs to go to the court. Always. So when you're handing it to the witness, you should be handing the original to the court. Or vice versa, you could hand the original to the witness because their court reporter is going to take it and then give the judge. This may be a mock trial rule, but nobody in trial says, can I publish the exhibit after it's been admitted? After it's admitted, you can do whatever you want with it. It's admitted. Okay? Published rule, okay, comes from when we didn't have this fancy equipment, okay? And publishing, I always knew can I publish to the jury? You would hand it to them and let them look at it in the box. Okay, that's what my understanding of publishing to the jury means. Putting it up on the screen, I mean, is it a mock trial rule, Judge Williams, that they have to ask to publish the exhibit after it's admitted?
It's not a rule per se, but I'm with you. Like when I was a young lawyer coming up, once it was admitted, we just started throwing it around and publishing was giving copies of it to the jury. So we didn't have all those fancy systems. But I think the prevailing system now is still ask permission to publish.
Okay.
So older lawyers are not going to get that. They're like, why are you asking that?
Move to strike. Okay, y'all were moving to strike. Unless it's really bad testimony for you, the only thing you're doing is accentuating it for the jury. Oh, this is so bad. I don't even want it said. And, you know, even if the judge, granted, they already heard it. Now they really paid attention to it because you moved to strike. Ooh, must be really bad. So with regards to this particular problem, all right, everybody keeps talking about this video. All the jury's wondering is, where is that video? Okay, so cross-examine of their expert, cross-examination of their expert. So, sir, you have based your entire opinion on a video that you saw, correct? Correct. Have you brought this video to the jury to show it to them?
We have it, we just don't like it. You didn't want it. Bad.
But that, where is the video? They're thinking, oh my God, the video.
Well, it was supposed to come in and then we ran into like a technical difficulty with the passcode and the witness was sequestered, so we couldn't the video, so.
That's
Yeah, constructively moved. Constructively moved.
I always remember to do that.
Yeah.
That was the funniest thing I ever heard. Keep all witnesses in the attorney ready. Like, what is going on here?
Well, he moved to invoke the rule. I even said, well, he didn't move to constructively invoke the rule. And you didn't say, oh, no, Judge, I want to constructively invoke the rule.
So you did it to yourself.
Somebody said the court did not subpoena you for trial or for testimony. Court doesn't subpoena anybody for trial. Parties subpoena people to trial. I don't ever subpoena anyone for trial. I'll hold them in contempt for not showing up on a subpoena, but I don't subpoena anybody. So on the expert cross-examination, 15K, and how many hours did you put in? Because that's a much bigger cross-examination point if you put in 2 hours for his 15,000 versus he put in 100 hours for his 15K. Okay, I think, so actually, I think. Oh. You. On opening.
You?
Said that the question.
Which you are you talking about? Okay.
You on opening stated that the standard was intentional and reckless.
I sure did.
You sure did. And you should have been objecting, Your Honor. I'm sorry, he's misstating the law. That's not the standard. I don't have to show both. I only have to show one. Oh, exactly. We have the pleasure. Which side said we have?
Oh, that is definitely me.
I like that, but I think you also need to say, we have the pleasure, and we also have the responsibility of representing the defendant. This is just not fun and games. You have a duty and a responsibility. It sounds more solemn. Oh, the question in one of the directs was, what did you see that caused you to believe that he was frustrated or something like that? A brilliant question. I don't remember who asked it because you avoided the hearsay exception. Very well thought out. Great question. That's all I have. And those are just kind of these things. Ms. Hudson, why don't you go next?
I think I was you and not me.
I'm gonna have to go first.
Good job, Haley.
Hudson is actually a former intern of the 295th with me during her first year of law school. And we have continued to be close friends since that time. So I've now given you some opportunity to think about what you want to say. So, Ms. Hudson.
Yeah, thanks, Judge. Yeah, thanks, Judge. My name's Haley haven't seen y'all before, but I am a personal injury attorney over at Abraham Watkins. I think y'all did a great job. Y'all all great advocates. I was not too long ago in y'all's shoes, so it's kind of nice to see the other side. Funny enough, this is my old coach, so it's kind of all coming full circle in the room. But yeah, y'all did great. I think my only critique is listen to what the judge says the first time. So, I mean, she said, I think 500 times, like, where's my copy? Where's my copy? I think everyone should have picked up on that because they don't like to ask things multiple times. So I think other than that, I think y'all did great. Y'all all were great off script, which is hard to do in the short amount of time that y'all had. So good job. Y'all all great.
Thank you. Why don't you pick up from that, Mr. Robinette?
Yes, sir. All right, I'll be quick. I've actually, except for you, Mr. Henney, I think I've seen you all before as a judge, so cool to see you again. I'll be really quick, something for each of you. Ms. Matthew, I thought the end of your direct was fantastic, where you pulled out the document and you started hitting what was said, right? You didn't get you weren't able to do the question, so you framed it like, did he also say, and do you also say? I think it's true, it's probably not. Technically, it's just leading questions, but you got away with it, so it's really impactful. And I think asking the do question kind of threw off. It didn't sound like a leading question, at least the way we're trained. Correct. So, and then I thought your cross was really methodical. You're good at that. Mr. Pierce, well, actually in MIL, right? I think I have the order right here. You argued basically that accident was a word that, they shouldn't be able to say. And you kind of get them to be like, no, it was an accident. We should be able to argue that. And then you brought up the 404B. And you're like, well, we're using it to show lack of accident, right? I mean, you kind of layered your second MIL for impact. So that was really, really good. And then obviously the rule invocation, I wrote, you got to speak up to stop it. When you realize you're like, oh, she's interpreting something I didn't mean. Judge, I'm sorry. If you could, right? I meant constructively, right? Jump in there. Don't just watch the train crash, right? And then.
But you'll never forget that, will you?
And I will say, your closing style, the same thing I saw last time. You have a way to connect with jurors and just get to the brass tacks of things to where it just clicks. And it sounds reasonable and persuasive and obvious, and you very highly persuasive on close. So I was really impressed. If I had one critique there, I would say on redirect, you're very likable, but when you nitpick your opponent on something little like villain story, right? I think it feels like a low blow, and I think it takes away from your natural likability. So I would just avoid doing stuff like that. Mr. Haney, I think you had some, I feel for you because I think in mock trial, right, we kind of teach impeachment a little differently, right? Whereas if they don't have a chance to review, then you have to ask them again. That's an extra step that I don't even teach my advocates. But I think you handled it well. You didn't fight with the judge. You took what you took it, and you went right back. That was well done. And I thought your redirect was fantastic. And Orly, you great methodical cross, great close, great structure. You know what you're doing, and you showed it well today. Well done. Good job, everybody.
Thank you.
All right. Ms. Roth is my daughter.
And you all have seen me around U of H because I'm one of the mock trial coaches.
So she will go next.
I'm a partner over at Searles Law. I do plaintiff's personal injury. What are the exceptions to invoking the rule?
Expert and
Parties.
parties.
So your client didn't have to technically leave, so therefore you wouldn't have had the iPad problem. Just saying.
Yeah, I was.
Just saying.
But again, you also will never forget that.
And I can speak up, so. Yeah.
In the cross, you knew he was going to admit that it was a stupid trial and a dramatic trial. You should have pulled that into your opening and pulled that in through your theme. Because those two words are very dramatic for a plaintiff's case. If you know a defense witness is going to say that, you want to use it to make them look like fools. So that's something I would pull on. Otherwise, I echo everything that has been said. And yeah, the video. I literally wrote, where is this video? I'm like, video, because I'm like any other. I'm like, oh, there's a video of this. Why can't we just watch the video instead of hearing about it?
All right, Ms. Herrera.
Okay, my name's Lauren Herrera. I left a big law firm about a year ago to start my own practice. I mediate. I also do plaintiff and defense, PI, and commercial work. You all did really great, especially in your opening and closings. All of you make great eye contact. I echo everything that everyone said. Yeah, video. What was the TikTok about? Mr. Pierce?
So the expert, right?
Yeah. Yeah, I didn't know like what I maybe I missed that whenever he was testifying about TikTok, but I was like, oh, TikTok. I don't remember TikTok.
No, like the social media promotion.
The social media. Okay,
Yeah,
because
I
I
guess I hadn't bridged the gap to TikTok specifically.
Okay. But everyone did really good. I don't want to. For y'all, for the plaintiffs, use the Elmo to go through the jury charge and have your co-counsel write it in. I started to write for y'all, and then y'all did it, and I was like, okay, good job. But yeah, definitely for y'all, because you want to show the jury what you want them to put in their charge.
Ms. Thomas.
Okay, so my name is Joy Thomas, and I coach mock trial at Thurgood Marshall. I'm an assistant coach there. I've been doing this since like 2014, and I'm the director of the Family Law Clinic at Thurgood Marshall, and I do the judicial externships at Thurgood Marshall. So I won mock trial, and I was in like I was mock trial. I was a police on an ICE agent in my first life. I've been a judge before. So mock trial is like my pastime. I live it and I breathe it. So I'm going to try to be brief, but my goal here is to try to polish you guys. Okay. So everything comes with love. I am nitpicky, but it's meant to, y'all are good. So I have to nitpick in order to make you better because you're good, all of you. I will say that I'll preface what I'm saying is do what your coach tells you to do. I'm telling you what I tell the students to do that works for them. Remember that sometimes when the program can get actual judges, you're going to have a real judge that's thinking from a courtroom standpoint, it's not always easy to get them, okay? So most of the time, you may have people like me who just see a request for mock trial judges and answers the call. So your goal is to get points. That's how you win. So your goal is not to do it exactly like you would do it in regular court. Your goal is to get points. So you have to let the scorer know that you know what you're doing. And sometimes that's not exactly what you would do in court. Okay, y'all changed it to fit Judge Roth's decisions, and that was great. But sometimes you have to do what, like, for example, you, sir, you asked Mr. Haney.
Yes, ma'am.
Don't ask for a ruling when you won. Like, you objected for lack of foundation, and she had her redo it. You technically won that. You only asked for a ruling when you lost, okay? And you're not gonna get a straight sustained all the time. You gotta kind of know when you won. I will say, well, let me go in order. Mr. Pierce is who talked first, okay? I can see you thinking about what you're saying, okay? So you need a poker face. You do. You need a poker face, and you need to say stuff with your chest. Sometimes in mock trial, you're not gonna exactly have your argument figured out or exactly remember the rule verbatim, but say it with your chest. Because sometimes your scorer is gonna just take your confidence and be like, he's got a point. But if you're fishing around with it, they're gonna fish around with it too, and it's gonna lose points. Let's see. Your shirt was untucked. That was distracting.
Yes.
It was distracting. You cleaned it up for closing, but you gotta put it together. You gotta look like $1 million and always stay on top of that. Y'all, and I blame you too. Y'all should be checking each other. Each of you should be checking each other. Okay. The defense said in his opening that that defense has to prove that he went out of his way to hurt someone or something like that. Y'all should beat him over the head with that. Like every time a witness came up here, because there was things you could have pulled out of your witness to say, to infer that he went out of his way to hurt somebody. And then in your closing, say that, throw his words back at him. What were you doing with the podium? I don't understand. What was going on with the podium? You kind of made yourself distracting by carrying around this podium. If everybody else is kind of going where they go with the flow. I think it was all of you except for Ms. Golub said no further questions. If I were up there where Judge Roth is, I would not have given you a redirect. I would not have given you a recross because you said no further questions. Be careful not to say that. You say pass the witness.
Or no further questions at this time.
Something like that.
You're hard. No further questions, like, hey, you're done here.
Well, sometimes you have two good teams, and it's these little things that will bring you over the top. It's like some of your judges are going to have to be nitpicky if both teams are good, especially in like a final round. They're going to be this nitpicky because both of y'all are good. I would say bring out your negative facts on direct. If you know in this problem that something like, if you know that he said the trial, we shouldn't hear from the cross that he said the trial was stupid and it was dramatic. We shouldn't have heard that the first time from the cross. In my trial, you have to let your scorer know that you know how to preserve error. Okay, so even if the judge, if you say move to strike, and you have to say, Mr. Pierce, move to strike everything after this word. Mr. Haney did that. Move to strike everything after this word that he said. Don't just say move to strike. That's not good enough. But even when the judge treats you like, oh, you're being extra, now overruled, you still have to say move for mistrial. You move to strike, move for mistrial. You're never going to get it, but that's how you preserve error. And you gotta let your scorer know that you know how to preserve error. Let's see. You want to learn the difference between a legal objection and a speaking objection. When you go objection, and then you just start talking. Like Mr. Haney was very good with objection. I think you did it so many times, I didn't write yours down. I wrote down when they were doing it wrong. But he would just say objection and what the legal objection was. And then go to the judge for the judge to ask the other side your response. When you say objection speculation, and then you say speculation as to this and that, objection speculation. And then let the judge ask for a response from the other side. And then whatever you're gonna say, you say if she comes back to you or you ask her, may I respond? Then you say all that extra stuff. Some judges will score you lower if you do speaking objections. Just stick with your legal objections. I'm gonna say, when you had a plaintiff, you had a witness that you had to object to speculation because he was talking about what everybody else said and what everybody else did and all that. But then when you ask him what he said, oh, I don't know. So you slap him with that. So on direct, you were speaking about to other people, but you don't remember what you said? Don't let him get away with that. You don't let him get away with that. Okay, Matthew. I will say that I teach the students that it's, other coaches tell me if y'all do this, it's may it please the court for opening and closing, and it's may I proceed every other phase of trial.
That's what I teach.
Okay, so is that what you teach? It's may it please the court, opening and close. Every other phase of the trial is may I proceed, and say it the same way every time. I will tell you, I teach the students too, it's easy to learn how to do lay your foundations when you say it the same way every time. Plaintiff, may I first witness? I'm showing the witness plaintiff's exhibit 2. Do you recognize plaintiff's exhibit 2? What do you recognize it to be? Is a picture, it depicts things. If it's not, has it been altered in any way? And plaintiff offers plaintiff's exhibit 2 into evidence. You say it the same way and you call it what it is. So this and that, all in pronouns is gonna get you, make you lose points. You want to use visuals. Like you're on direct, you're literally painting a picture for somebody. You want to invoke all their little senses. So somebody mentioned a glare. What the glare look like? Let us see it. Have them make the little glare on his face. You know, like if they, you know, none of you took me to December, it's cold outside. And like this is a tennis match, like kind of use what the story gives you to invoke all of our senses so that we can see and feel and all of that in your story that you're trying to tell on direct. In your closings, you should touch every exhibit that you entered, that was entered at least once. While things are being entered during the trial, you have your jury charge, so you know your elements. You're attaching what exhibit proves or disproves what element. And when you tell your story, when you go through the whole trial in closing, you're dealing with all these exhibits. You should be dealing with all of your exhibits that were entered when you close. Let's see. I think Miss, let me see. You guys needed to organize your desk. It was distracting. So I teach my students to have stacks. For your exhibits, you should have at least 3 of them, okay? Typically, when you're approaching the witness, you're gonna have 3 of them. You're gonna brandish to the other side as you walk into the witness. You have 1 for the witness and 1 for the judge. A judge should never have to ask you for something, ever, okay? You shouldn't even ask the judge if they want a copy, just give it to them. They'll tell you if they don't want, or they'll send it to the side, okay? And so you have 1 copy for the judge, 1 copy for the witness. The other one is because some teams will be petty and be like, oh, I didn't see that, let me have it, let me hold it, let me touch it.
So here, just so that you know, the problem with that is they were only given a limited number of copies of the problem, and they don't have the ability to print it.
Okay.
And I would not let them print anything.
So would you?
Judge one, we
we give the judge one of our copies.
Okay.
Yeah,
So,
they-
but you would, like, you typically have them print out more.
Yeah, but this is a very special circumstance.
Okay,
They
so,
literally only were given a
So
limited
ignore-
number of copies and they know that I was not gonna let them print out anything else.
so ignore me. Y'all already know what I'm saying. Excellent deal. Okay, but in doing that, you should have, and I want to make sure, like, I saw some of the exhibits that y'all had been highlighted and written on and all that. Y'all weren't showing that to the witness, were you? No. Okay, you always show them a clean copy, right? Okay, because you know they'll object to hearsay on the, all that kind of petty stuff. So you have a space on your desk where y'all always keep exhibits. You have a space on your desk in between y'all where you keep notes or something, like have spaces on your desk where you keep things and put them in their place so that you're not all over the place.
They're close to the end because they want to know who won.
I'm sorry.
It's been a very long weekend of competing.
Okay.
This is their sixth round in literally.
I will say in
2
mock
days.
trial world, you don't refresh a person's memory unless they say they forgot. When they, the trigger word is, do you remember testifying differently? When they lie, when they straight up lying, you impeach. And when they say they forgot, then you refresh their recollection. I think in your, did he ask for time for a rebuttal? Did he reserve
Yes,
time?
I
for
reserved 2 minutes.
Okay, in your rebuttal, use that, I agree with whoever up here, Mr. Robinette.
Yes.
He said that you did kind of take away from your likability by being petty, but she gave you gold. She said he might have been careless, but he wasn't reckless. It took me 2 seconds to go to my phone and look up the definition of careless. It looks a whole lot like reckless. So careful with that, but she in her own admission said he was careless. Let me give you the definition of careless and let's see how much that looks like reckless. And that's all we got to say. Like, just get a good solid point or just don't even rebut. Don't rebut just to rebut. Have a purpose for it. And because usually you have to end and the judge is sick of y'all by now. So if it's not meaningful, don't do it. Okay. That's good.
Thank you. Well, so I appreciate having all these judges here because in part we do have a real judge today. Thank you so much, Judge Ross, for giving us the opportunity. But what is well represented here and what I appreciate is we have people who coach from Thurgood, who coach from South Texas.
I'm
and
just gonna
obviously-
say thank you to everybody. Thank you so much.
Just let mom do her thing.
Yes,
Thank you.
Can't control her.
Get on.
Yeah, it was so nice to meet you. It's nice to meet you. Oh, well, you can take over.
Okay, thank you. But it's great because what this tells you about, and what I can't ever emphasize enough, is that we are a true legal community here in Houston. That it's not just about, every school looks out for themselves or something like that. I mean, everybody who teaches mock trial in Houston wants to make advocates better, unless Billy's just here scoping out, like, how the competition's gonna look like against them for the future. But I appreciate all of y'all being here. It's very, very meaningful to me, and I think it's great credit to our program. You guys always represent us very well. And what I've loved hearing over and over again this weekend from all the judges is, damn, how good the team is, because that's all the work that y'all are doing, all the work that your coaches, who are alums of the program put into it, it all pays off. So before we get to the really, really fun part, remember what I was saying about pay it forward. I have to thank, your alums like Megan Rose, who got Craig Jewett to sponsor meals for this tournament. Alums like Karina Sanchez, who got AZA to sponsor meals for this tournament. And then Troy Chandler, who's an alum, is the reason why 2 of y'all are about to get outfitted quite nice as a result of this tournament. That's how they pay it back, by paying it forward to y'all. So I have to acknowledge them and recognize them because it matters a lot. So first we're going to give the outstanding speaker of the final round. The congratulations to Lily God.
I'll take the pictures. Where do you want your picture?
They're all a little wet. Don't hold it.
You know her so well.
I literally painted them like 2 days ago. And because of the humidity, they're all still very tight.
You're live on WhatsApp.
Okay.
It's usually what happens, because that's where I
So we're gonna do pictures with the finalist team, and then we'll do pictures with the winning team. Right? So the finalist team, which is still a huge achievement, but congratulations to team A and B. I have little ducks for you, and I made one for the coach too, so Brett, you get one too. These are also very wet. Do not hold them close to your clothing.
Brett gets put it in his office.
I know.
He's over at Ryan McLeod's office, Jason Webster. And then all of them over there.
Please, the championship team this year is first class.
Jay, you're a little too excited.
We got one for you too, Shay. Again, they're wet, don't hold it close to the We are gonna do a photo with all the judges as well.
I'm gonna run out to the garage. I'll be back in 30 minutes.
No,
I'm kidding. I can't go anywhere. I drove my mother here.
Hey.
I actually can't get out to the garage. I need her. I look pretty today.
You don't want it, I got it.
I'm really glad I didn't.
I'm really sure I did the casual thing, but I was like, you know what?
Yeah.
Oh, yeah, super business casual.
This works. Like, this is my business casual.
My mom was like, do not wear leggings.
I put my work on.
I put my flats on.
I wear a suit.
I told my mom I would not wear leggings today.
This is the part that I really want.
I'm coming. Okay.
I'm really a little scared.
Guys, take a picture with everyone.
Donna, get my phone to Jessica. Yes, we'll take a picture. Yes, the image. Everybody Oh, look fabulous.
How's my hair look?
We got the ball. We have governmental immunity.
Ready? 1, 2, 3. 1, 2, 3. Okay. Do you want
And you're on portrait mode. Might be on portrait mode.
Ready? 1, 2, 3. I think that's it.
Okay, congratulations, Taylor.
It's so good.